is open. Can you hear me?
Yeah.
Good. My name's George Baird. I'm a Chartered Town Planner and I'm the inspector appointed by the Secretary of State to conduct this appeal and determine the appeal. This is an inquiry into an appeal made by Industria Solar Vigo Limited under Section 78 of the Town and Country Planning Act 1990 against the decision of Swale Borough Council to refuse planning permission for the construction of a solar farm together with ancillary works, including landscape and grid connection. I'll take the names of those who wish to be heard. Who appears for the appellant?
Then, sir, good morning. My name is David Hardy, that's Hardy, partner in CMS. I can introduce my team, they can speak for themselves, but to my right, Mr. Fidget, dealing with planning, and then Mrs. Green, who's going to deal with landscape and visual matters, and then Mr. Rose, dealing with agricultural matters there, and I have two representatives from the client sitting behind me.
Thank you, Mr. Hard. When your witnesses are giving evidence, we haven't got a lot of options here for taking them away from the partners.
I assumed they would just sit up there next to you.
Right.
The support officer, who probably knows, just left the room for a moment. But I think the witnesses for the highest inquiry will see.
You happy with that, Mr. Hardy?
Yes, subject to how we're going to run what are effectively our roundtable sessions, yeah.
I should say in that regard, so if it's run more formally as a roundtable, we don't object to the members of the appellant's team staying where they are, but it's a matter for you as to what you prefer.
It's just when they're giving evidence in chief.
Yeah.
Just move to there.
Yeah.
Or would you prefer that they sit on the other side so you can...
I really don't mind.
Can't see them on that side with all this stuff here.
Oh, of course, yes.
If you just move up here, then everyone can see and hear. Right. And for the local planning authority?
So my name is Matthew Henderson, barrister, and I'm instructed by the borough solicitor. And accompanied with me today is Mr. Ben Oates, who is the appeal case officer, who can assist you on matters of conditions, etc. in due course.
Thank you. Now, is there anyone else who wishes to be heard? Mr. Councillor Small from Borden Parish Council has indicated a wish to speak. And we've got Mr. Sewell.
Yeah,
and Mr. Wilmot.
yeah,
And there's a Mr. Browse who is intending to appear virtually. And I think I can just see
yes,
a small
Present.
picture of Mr. Browse on the bottom of the screen.
correct. Thank you.
Excellent, thank you. Now, just a couple of matters of housekeeping before we start. Can you familiarise yourself with the emergency exits, just in case all our computers and notes spontaneously combust, or Mr. Hardy gets overheated at some stage during the inquiry, and as he is wont to do in the past. I've met Mr. Hardy before, and he can. If you've got a mobile phone, could you switch it off? And if you can't switch it off, can you switch it to silent, please? Does anyone intend to record or film the event? No. Okay. Right. In terms of the microphones, if you're going to use the microphone, mine stays on all the time, but I understand that if you use any of the other microphones, switch it on to speak and then switch it off when you're finished, because no one else can use a microphone if yours is left on. Okay. Now, I have a copy of the Council's letter of notification and the list of persons I notified. Mr. Hardy, did you receive a copy?
Yes, I did, thank you.
Now, in response I've received 5 representations. Mr. Anderson, Borden Parish Council ×2, Mr. Browse, the Environment Agency, Mrs. Josephine Philpott, who supports the proposal, and I have the responses from Mr. Sewell and Mr. Wilmot. Have any other letters been received? No. Now, representations made at the time of the application will be taken into account when I come to my decision. We come to the matter of amended plans, and following the submission of the application, the appellant requested that the appeal to be determined on the basis of what was known as option 2, which had 7 elements: removing development from fields 5 and 6, moving the panels away from the site boundaries, amending internal site boundaries to widen footpaths, for the provision of additional landscaping, moving fencing and development away from Wrens Cottage and straightening part of the northern boundary, and reorientation of the panels to reduce impacts from glint and glare. At the April case management conference, I indicated that the proposed amendments fell within the substantive elements of proposed changes, and the appellant carried out a public consultation exercise in relation to those proposed amendments. And following an examination of the responses, I confirmed that the inquiry could proceed on the basis of the amended plans. And then the council confirmed on the 20th of June that had those amended plans been before it, the application would have been supported. And the council confirmed that it would not be producing evidence to substantiate the reasons for refusal. And before I ask Mr. Henderson and Mr. Hardy if they want to say anything else about amended plans, is there anyone else who wishes to comment? Mr. Henderson, Mr. Hardy, do you want to say anything about the amended plans?
Simply to confirm, sir, because I left the position open at the CMC, that in the intervening period the appellant has undertaken that consultation exercise and satisfied the council that there's no consultation deficit, and therefore we don't object to you considering option 2 for the purposes of your decision making.
Right, okay. Well, on that basis, just to formally confirm that the appeal will be determined on the basis of plans that comprise option 2. In terms of procedure, I will identify what I consider to be the main issues on which the decision will turn. I will hear opening statements starting with the council, followed by the appellant. And at the April case management conference, I asked that 2 areas be covered, either in evidence or in the opening, which were the impact of the New Forest National Park Lillington case and the duty that places on the decision maker, and whether there's an inconsistency between the guidance contained in the March 2015 written ministerial statement and the latest iterations of national policy, including the May 2024 written ministerial statement. And then, following confirmation that the council would not be pursuing the reasons for refusal, I requested that the council advise me on how, given the reasons for refusal, the proposed amendments made the proposal acceptable. Now, following those statements, I will hear representations from those people who indicated they wish to speak. And we'll start with Councillor Small, followed by Mr. Browse, and Mr. Sewell and Mr. Wilmot. You're happy to make your representations once you've heard the statements from the council and the appellant? Absolutely. Excellent. Thank you very much. Following those, Mr. Hardy will then call his witnesses, and witnesses will be open to question. And after hearing the case for the appellant, I will ask again if there's anyone else who wishes to make representations. The evidence will be followed by a roundtable session on suggested planning conditions, and the fact that I will deal in detail with suggested planning conditions should not be taken to mean that I've reached any conclusion or minded to allow the appeal. It is a process that I am bound to go through. The list of suggested conditions attached to the statement of common ground contains several pre-commencement conditions, and I'll need a note from the appellant indicating agreement to or an agreement to accept their imposition. That could be sent to the case officer.
Yes, we'll do that.
Thank you. Now, has anyone any difficulty with those arrangements? Oh, I've omitted to say after conditions, Mr. Hardy, if he wishes, may make closing submissions. We'll adjourn for lunch sometime around 1 o'clock, and if necessary, we'll adjourn for the day at around 4:45. But that said, I believe we'll cover all of the evidence and business today. And I'll look to you, Mr. Hardy, to identify appropriate places during the presentation of the evidence for mid-morning and mid-afternoon breaks. And further to planning guidance on the award of costs, if there is to be an application for the award of costs, this should be made before the inquiry closes. Does anyone intend to make an application for costs?
No, instructions at the moment are not. In relation to the round tables, what I proposed in the timetable was about 15 minutes for a truncated evidence in chief to give you the main points.
Yes.
If that's done, the question that my witnesses had was, would the questions in the round table be led by presumably yourself, and then would third parties be able to ask questions as part of that process? So in other words, will there be active participation from others aside from the witnesses and yourself?
Well, if someone has questions, even under the normal arrangements, they would have the opportunity at my discretion to ask questions.
Yep.
And that is not going to change. I have got a number of questions. They may be answered during your presentation, but if not, I've got potentially several questions for each of the witnesses.
Yep.
And if anyone else has questions, they will be able to ask them.
Is that just by raising hand?
Or you can throw something. I was banking on that. Right. Now, I have visited the site and I've viewed it from public vantage points. There will be an accompanied site visit after the close of the inquiry where relevant features can be pointed out, and we'll identify when that will take place. I'm anticipating that will take place tomorrow morning.
I think an itinerary that
Yes.
we sent in, I hope was helpful.
I've got that, yes, and I followed the majority of it yesterday, but I'll return there and we'll visit and we'll drive and walk the itinerary. Have you seen where the appellant and the council want me to go
No.
Can someone provide Mr. Sewell and Mr. Wilmot with a plan? And you can, if there are any other places that you want me to visit, if there are any other places that you want me to visit and view the site from, you can raise those at any time during the proceedings, and just let me know where you want me to go. Now, in terms of documents, I have from Mr. Fidget a proof, appendices, and summary proof, from Miss Green, proof, appendices, and summary proof, and Mr. Rose, proof, appendices, and summary proof.
Yep.
And there's a suite of core documents hosted by the council on its website.
Yes.
Now, I received yesterday the revised statement of common ground with the list of suggested conditions. I take it those are agreed conditions given they're in the statement of common
Yes.
ground. Right.
I think there's one additional condition that we're going to propose, which we've discussed, and that is a soil management plan condition, but we can deal with that in the break. We've got a model for that.
Right. Okay. I've just got a few queries in relation to the conditions, and we'll deal with that during the roundtable session. I asked for a note in relation to the public footpaths and their widths. Has that been able to be prepared?
It is. It's here. Yep. Got
And which of your witnesses will?
That's Mrs. Green that's prepared that. So any questions on this to her?
Okay. Excellent. Just going back to the statement of common ground, I've got one query, and it relates to paragraph 2 to 11. It also pops up in one of the conditions. 2 to 11 says the energy generated and stored by the proposal. There's no, I understand there's no storage. So that pops up in one of the conditions. Condition 15.
Yes. It should just be generated.
Yeah. Right. Okay. Right. Okay. In terms of the main issues, at the case management conference, based on the reasons for refusal, there were 3 identified. But following the council's acknowledgement of the suitability of the proposal for this location, I consider the main issues to be addressed are the landscape and visual impact of the proposal and the effect on the supply of agricultural land. Impact on public footpaths would be dealt with under visual impact in terms of the first main issue. Are you happy that those cover
Yes.
what I need to address?
So can you just repeat the second?
The effect on the supply of agricultural land. But those are just the main issues. Matters that you will raise, the parish council and others that have raised in their representations, I will deal with under the heading of other matters.
Yeah, I wasn't worried that you were missing what you might be saying. It was just I couldn't remember the second one that you were picking up. Just the, yeah. So, thanks for that consideration.
Anything you wish to raise, Mr. Henderson?
So no, happy to proceed on the basis you set out. Thank you.
Mr. Hardy, anything you wish to raise?
Nothing else, thank you.
Excellent. Mr. Henderson.
So yes, I've got reduced my opening into writing, so I'll distribute some copies.
Excellent, thank you.
And so there's one short oral addition I'll make just to deal with the note that you've been given this morning on the public rights of way, but I'll pause at the relevant step.
Just let me check. Mr. Bryce, you can hear.
Yes, I'm hearing fine. Thank you very much.
Thank you.
Grateful, sir. So this is the opening statement on behalf of Swale Borough Council. On the 28th of April 2023, the appellant applied to the council for planning permission to construct a solar farm on the appeal site. On the 6th of August 2024, the council's planning committee considered the application. The committee had the benefit of a report from the council's officers. In that report, the officers identified a range of harms and benefits arising from the proposed development. The committee disagreed with the officers' on-balance recommendation to grant planning permission and instead decided to refuse to grant planning permission. In essence, the committee considered that the balance of harms and benefits tipped against the grant of planning permission on a cumulative basis. This is reflected in the decision notice issued on the 9th of August 2024, which identifies cumulative harm caused by the proposed development, which is not outweighed by the public benefits, having regard to three key concerns. First, the impact on the character and appearance of the area, with specific regard to the setting of the Kent Downs national landscape. Secondly, the impact on the public rights of way that traverse the appeal site. And thirdly, the loss of best and most versatile agricultural land. On the 4th of February 2025, the appellant lodged this appeal against the council's decision. Within its statement of case, the appellant set out, for the first time, an amended version of the proposed development, referred to as Option 2, being distinct from Option 1, which was considered by the council's planning committee. These amendments were specifically intended to address the council's reason for refusal. At the case management conference on the 14th of April 2025, the appellant confirmed through its legal representative that it wished the appeal to be determined on the basis of Option 2 only. On the 22nd of May of this year, the council's officers reported Option 2 to the council's planning committee, and the committee was requested to take a view as to how the amendments and any associated alterations to the benefits and disbenefits of the proposed development would affect their position on the acceptability of the application. The minutes of the meeting record the committee's resolution that it can be concluded that the amendments to the proposal are sufficient to make the proposal acceptable. Given this, the council explained in correspondence on the 20th of June this year that following this resolution, the council will not be producing evidence to substantiate the reasons for refusal, as they only relate to Option 1. The council have proactively considered the amended proposal and reached the conclusion that the amendments alter the plan balance in such a way that, had these amended plans been before the council, they would have been supported. Accordingly, the council's position at this appeal is that plan permission should be granted for the proposed development in its revised form as Option 2. It is clear from this series of events that the council acted promptly and diligently in reviewing its case once Option 2 was presented by the appellant. It is to be noted that the appellant has, rightly, not made any criticism of the council's decision to review its case. I turn then to the revisions of the proposed development. The principal amendments to the proposed development, being the differences between Option 1 and Option 2, are as follows. The solar panels are further offset from the site's boundaries. The internal development boundaries within the site are amended in order to widen the public rights of way which traverse the site. The site's fencing is further away from Wrens Cottage. The northern extent of the solar panels is moved further south, so away from the properties off Ode Street. The fields and parts of fields referred to as areas 5 and 6 are removed from the developable area within the eastern extent of the site, such that the eastern boundary of the solar farm is now to the west of Wrens Road, not to the east. The solar panels are reorientated to address glint and glare on the M2 motorway corridor, thus allowing the removal of the previously proposed mesh fencing along this boundary. These amendments are cumulative in nature and effect. Despite the appellant's transparently tactical attempts to describe these amendments as slight, they are in fact extensive and highly material. This is not to say, and the Council does not now say, that the amendments result in the proposed development being in substance different from that which was applied for in the application, such as to be impermissible. However, this conclusion on the permissibility of the amendments is simply a reflection of the fact that option 2 represents a reduced position within the parameters of the application, not because the amendments are limited in scope or are not material. The Council also accepts that there is no procedural bar to consideration of option 2, given the consultation undertaken by the appellant to deal with the risk of unfairness. The key takeaway from these amendments is that they help to reduce the impact of the proposed development on the environment, as the appellant accepts expressly. I turn then to the Council's revised position. The Council's revised position on the reason of refusal is as follows. On the first limb, in this limb, the Council alleged that the proposed development would result in, at least, moderate adverse landscape character and visual effects on the site, in the surrounding rural landscape, and specifically within the setting of the national landscape. These concerns were underpinned by feedback from the Council's consultant landscape architect, Peter Radmore Associates, and a negative consultation response from the Kent Downs AONB unit. In broad terms, Peter Radmore Associates identified a series of obvious concerns about the appellant's LVIA and assessment of impacts on the character and appearance of the area. In particular, the appellant's assessment of the sensitivity of the national landscape, the setting of the national landscape and the site was inaccurate and unduly low. The appellant's assessment failed to reflect the fundamental change that the site will undergo from a parcel of farmland to a commercial solar farm, including loss of its characteristic arable use and openness. And given both of these matters, the appellant's assessment of effect was inaccurate and also unduly low. Some substantial effects are likely. The proposed mitigation, the enhanced landscape structure from planting, would provide visual mitigation, but would also continue to exert harmful effects on openness and, in particular, the amenity of the public rights of way even after decommissioning. The appellant's response to the Peter Radmore Associates review was unconvincing, being essentially a limited response on the issue of visual effects. A more detailed response has been provided since this appeal was lodged, albeit not one that the Council agrees with entirely. Further, both Peter Radmore Associates and the AONB unit identified particular concern about the impact of the proposed development on the setting of the national landscape. On the approach to this issue, the Council highlights, in response to your pre-inquiry note, sir, the following matters. Paragraph 189 of the framework requires that development within the setting of the national landscape should be sensitively located and designed to avoid or minimise adverse impacts on the designated areas. In addition, even where a proposal is outside of the national landscape, the effect on views outside of the landscape but gained from within it would engage the policy protection in paragraph 189. Great weight should be given to the conservation and enhancement of landscape and scenic beauty in such views. For the same reasons, the statutory duty in section 11A, subsection 1A of the 1949 Act is engaged by such views outside of the national landscape but gained from within it. The duty under that section is properly characterised as a strengthened duty when compared to its predecessor. To comply with this duty, the decision maker should first assess whether the proposed development will accord or conflict with the purposes in section 5, subsection 1 of the 1949 Act. If there is conflict, then the decision maker should go on to consider whether to grant planning permission and to explain why they have decided that planning permission may justifiably be granted. This may include consideration of the size and scale of the development, the extent and severity of conflict with section 5, subsection 1 purposes, and any mitigatory or compensatory measures, and I refer there to the relevant paragraphs in the New Forest National Park Authority case. Section 85, subsection 1A of the Crow Act 2000 contains a similarly strengthened duty. I referred you to the more recent CPRE case, but again, the same approach to this statutory duty applies as that which was explained in New Forest. So then on this issue, it is common ground that the proposed development will cause an adverse effect on the setting of the national landscape, even in respect of option 2. This includes an adverse impact on the long-distance views from the national landscape, which are an important characteristic of the designated area and were noted indeed as a key reason for designation of the then AONB back in 1968. However, the council, but not the appellant, identified a particular sensitivity in this location. The AONB unit's set and position statement highlights that views to and from land which has landscape character linked to the Kent Downs, such as dry valleys, may be a location where development and changes in the national landscape setting may be more keenly felt. In northward views from the national landscape, the site contributes to a degree of perceived continuity between the designated area and its farmland setting beyond the M2 motorway. Notably, these views are from locations within the Tunstall Farmlands LCA. The proposed development has the potential to interrupt this continuity and to create a visible association with the existing industrial or infrastructure features and views towards Sheppey. It follows that under both option 1 and 2, harm to the setting of the national landscape is unavoidable, so too harm to the local landscape, leaving aside this setting issue. The amendments within option 2 have reduced the adverse effects on the character and appearance of the area, including the setting of the national landscape. This is common ground with the appellant. This reduction straddles the impacts under reasons for refusal limbs 1 and 2. As to the former, so that is to limb 1, the area of the solar arrays is reduced by approximately 15%, particularly by the removal of areas 5 and 6, and this reduction is augmented by the setback of the solar arrays from the site boundaries and the breaking up of the arrays within the wider public rights of way. Option 2 results in a more compact and less expansive development, particularly in views from the national landscape. In addition, it reduces, on the appellant's own evidence, the effects on sensitive residential receptors to the east. Overall, these are important amendments which materially reduce the harm under this limb of the reason for refusal. Turn then to the second limb. By the second limb of the reason for refusal, the council alleged that the proposed development would result in a harmful feeling of enclosure to the public rights of way routes through the site by virtue of their proposed width and proposed adjacent screening. The council also identified safety issues regarding the site access for construction across public rights of way route ZR137, and the upshot of those adverse effects is harm to the amenity and well-being of users of the public rights of way and in economic terms. On the first issue under this limb, harm to the amenity and well-being of public rights of way users, it's common ground that those users are that those public rights of way are important contributors to the enjoyment of the countryside in this location. The enlarged field sizes as a result of fragmented hedgerows and or lost internal field boundaries are a key characteristics of the LCA evident on the site. The openness of the site and the surrounding landscape is a feature of medium value. The site and wider area has recreational value due to the network of public rights of way and the toll right. In these circumstances, the proposed development will have an adverse impact on the public right of way. The width of the public rights of way, coupled with the adjacent hedgerows at some 3 metres high, results in a material adverse impact both on the key characteristics of the enlarged field sizes in the LCA and the openness of the site and the surrounding area, to the obvious detriment of the recreational experience. It's also common ground that some of the adverse impacts on the users would be substantial. All of these impacts are permanent, not temporary. Option 2 represents a material improvement for those receptors, given the increased width from 7 metres to 10 metres as a minimum, a 40% improvement as the appellant acknowledges. And indeed, so I just pause to note here 2 matters from the note that was given to you. Now, I've said 7 to 10 metres as a minimum, but if you turn to page 2 and look at ZR134, it's actually slightly greater. It's from a minimum of 6 metres under option 1, hedge to fence, to 10 metres hedge to fence under option 2. And I draw your attention also helpfully on the same page to ZR169, where of course the change is much more pronounced because the development is no longer adjacent to that route. So they are further examples of the materiality of the change which option 2 has brought about. I return then to paragraph 29 in my written text. On the second issue under this limb, Kent County Council has documented the economic effects of access to the countryside on public rights of way. In this regard, site-specific evidence is available from the outdoor recreation valuation tool called Orval. The County Council explains Orval is a map-based web application. It provides further evidence of the value and benefits that are derived from publicly accessible space and the PROW network. Orval shows usage and welfare values that are generated by accessible green space, either as an individual site or as a region. The welfare refers to sense of well-being or utility that each person feels as a result of their experience. The welfare value for green space is the figure for the monetary equivalent of the welfare enjoyed by a person as a result of having access to that green space. The welfare value can be used when applying cost-benefit analysis to assess future planning applications and projects that impact on the PROW network and other accessible green space. It's supported by DEFRA and endorsed by the Treasury. In respect of the site, the available data within Orval indicates, firstly, that there were 43,051 visits per annum for Bridleway ZR134, with an associated welfare value of £111,000 per annum. And secondly, that there were 16,416 visits per annum for footpath ZR137, including some linked routes off that footpath, with a welfare value of £42,000 per annum. KCC also provide an additional approach based on the Natural Inland Monitoring Engagement data. The NEAM data indicates an average local spend per visit of £6.44. Using the annual visits recorded on Orval, this equates to £277,000 of local spend for ZR143 and £105,000 of local spend for ZR137. Similar figures for the other footpaths are likely, given the common characteristics and similar usage. Public objections attest to the popularity of these routes, which has also been observed by the council officers on site and are known to members of the planning committee with their local knowledge. It follows that by either measure, the enjoyment of these footpaths has an important economic value, whether assessed in terms of welfare value or local spend. Given this, the adverse impacts on the amenity of users of the public rights of way is likely to reduce the number of visitors and result in an adverse economic impact on either measure. That is consistent with KCC's evidence position that one of the top three issues limiting or preventing public rights of way use is the pleasantness of the environment and the experience. However, critically, the improvements under option 2 assist with limiting this impact, given the material reduction impacts on public rights of way users resulting from that option. Reason of refusal limb 3. By the third limb of the reason of refusal, the council alleged that the proposed development would result in the loss of best and most versatile agricultural land, which, albeit temporary, would render the site unavailable for farming for food production during its use. The numerical position is agreed. Under option 1, the proposed development would result in the temporary loss of 54.62 hectares of BMV land, and under option 2, the proposed development would result in the temporary loss of 46.28 hectares of such land. It's also common ground that on this basis, option 2 significantly reduces the impact on BMV land, my emphasis, having particular regard to areas 5 and 6. Accordingly, whilst the loss of BMV land under either scenario is significant, particularly bearing in mind that it clearly exceeds the statutory threshold for notifying natural inland, nevertheless option 2 represents a material improvement and thus a material reduction in harm under this limb. The pre-inquiry note, sir, you asked whether there is an inconsistency between the guidance in the WMS from 2015 and later iterations of national policy, including the 2024 WMS. These documents are all in line in their recognition of the benefits of BMV land. The national policy statements and the WMSs are also aligned in that the use of BMV land needs to be justified and that lower quality land should be used in preference to higher quality land. The 2024 WMS does not depart from that established position, and indeed the established position under both other national policy documents and especially policies DM20 and DM31 in the development plan, that competing policy objectives must be balanced. However, the 2024 WMS is clear, in much more explicit terms, that in approaching this balancing exercise there must be a particular focus on whether impacts on BMV land have been minimised, underline that word, bearing in mind that BMV land is the least appropriate for solar development. Applied to this case, the council is satisfied that option 2, with its reduced footprint for the same output, reflects an appropriate approach to minimisation that was not provided with option 1. Then to the countervailing benefits. Ultimately, this case, as with many, if not all, renewable energy schemes, and especially solar farms, is a question of balancing the harms against the benefits. For the reasons given, option 2 has materially reduced the identified harms, about which the dispute has only ever been the extent of harm, not whether in fact harm would arise. Further, since the decision under appeal, there has been a notable policy shift in support of renewable energy development, including solar farms. Most notably, paragraph 168 subparagraph A of the latest iteration of the framework now states for the first time the local planning authority should give significant weight to the benefits associated with renewable and low carbon energy generation and the proposal's contribution to a net zero future. Again, my emphasis, significant weight. This is an important material change in national policy that is directly applicable here. In addition, there are a range of other government policy statements which post-date the decision under appeal, which have materially improved the policy support for the proposed development. In particular, the government's Clean Power Action Plan from December of last year and the government's Solar Roadmap, June of this year. It is unsurprising that both policy documents now form central planks of the appellant's planning case. The relevance of these policy documents is also demonstrated by the contrast between the specific support they provide for the proposed development in comparison to the more general and less specific support for renewable energy in other documents, including mere consultation documents relied on within the appellant's planning case. So to the revised planning balance, the appellant now seeks planning permission for option 2 only. The appellant does not present evidence to justify the grant of planning permission for option 1, whether the date of the council's decision under appeal or today. Having regard to both the reduction in harm arising from option 2, as well as the increased policy support for the proposed development, the council has restruck the plan balance and concluded that the benefits now outweigh the harms, such that plan permission should be granted for option 2. So to conclude, for those reasons, the council's position today is that plan permission should be granted for option 2.
Thank you, Mr. Just one point.
Yes.
Can you go back to your paragraph 29?
Yeah,
You start on the second issue
yeah,
and Kent County Council.
yeah.
When I look at the committee report,
Yes.
none of that was mentioned in the committee report to the planning committee.
Yeah.
And this is the first time that this has appeared, as
Well,
far as I can see.
Well, so the reason, and I can be very clear, the reason for paragraphs 29 through to, indeed, through all the way to 33 is because in your pre-inquiry notes, let me just turn it up if I may, and I think it also in later correspondence from the inspectorate at your direction, you raised a specific point, so sorry, just bear with me whilst I pull it up.
Yes.
So I'm looking at CD 3.58, so that paragraph 6 on the second page. Sorry, it's not page 6, but you asked us, it was not that paragraph, but you asked us in short to specifically justify why does limb 2 of the reason for refusal make reference to economic impacts, and therefore I'm responding directly to that, sir, because this is what was in was underpinning those concerns in discussions with KCC. So you won't see it in the officer's report, sir, and I wouldn't otherwise have made any reference to it, but you've asked us a specific question. And this is me dealing with that specific question head on to help you, I hope. But to be clear, as I've said, if you go slightly further forward in my written text to paragraph 34, ultimately we think that was a justifiable position at the time, but the position is now different under option 2. And hence you've seen our restriking of the planning balance. But we're not putting those paragraphs in there to make mischief, sir. It's simply because you asked us a specific question and we wanted to give you a specific answer.
But just so that I am clear, none of those figures were before the planning committee when they made...
No, sir. They were in consultation emails that weren't put before the committee.
Okay. Thank you, Mr. Henderson. Mr. Hardy.
So just before I start, picking up on that point about paragraphs 29 onwards, we've not seen that material before, nor, just talking to Mr. Fidget, have we had chance to interrogate the model. We don't object given where the council has landed, but an observation I think that Mr. Fidget will make is that the figures, which are set out in paragraph 31, do seem to be very high. When you look at the footpaths where they go, sort of usage that we've seen, to attribute a financial value of over £250,000 of local spend to ZR143 and 105,000 to ZR137 is surprising. I put it no higher than that. I don't know, given where the council has got to, how interested you're going to be in those figures. We are not in a position today to deal with that modelling basis or the types of values given. So if you are interested, I'm afraid we can't help you today, but we would ask for time. It may be that you take a view that we don't need to go into it any further given the reason that's been suggested by the council. So I'm not objecting, just saying we haven't seen it, and it is slightly eye-raising. We also, I think Mr. Fidget said that you weren't aware of those figures in email correspondence that you've seen. So I don't think it wasn't that it wasn't just that it wasn't in the report. We haven't seen those in the email correspondence either.
Well, sir, I mean, I'm super clear. I'm happy to strike through those if there's no blowback on me from you. So my learned friends helpfully said there's no cross-application from him. I'm simply being very defensive on behalf of my client, that I don't want you to go away thinking we've not had a justifiable case at an earlier stage and therefore initiate an award of cross against us. If there's no risk in that regard, so I'm happy to strike through those paragraphs and simply move on. I'm simply, and frankly, being very defensive to deal with the point you've raised earlier on this issue.
The issue was raised at a time when the council were proposing to defend the reasons for refusal, and on my reading at the time there was an absence of anything to do with economic justification within the report to the planning committee, because that's the information on which the members based their decision. And if that reason was to be pursued, then my warning was that the council would need to present evidence to support that reason for refusal. When the council in June determined that they were no longer intending to present evidence to support the reasons for refusal, I did not anticipate that this type of information would come forward. And well, I'll lay my cards on the table. I'm still pondering whether I should invoke my own powers to award costs on the basis of an unreasonable refusal, and the requirement for the inquiry to proceed. And I have come to know clear conclusion on that. Mr. Hardy, in terms of what you would want to consider and what want to present in relation to that information, how would you see that being done?
Mr. Fidget simply hasn't seen the model. I don't know how these figures are arrived at. Just looking at them for the first time, they seem extraordinarily high, that's all we'll say. But the council does, and to be fair to them, take those points into account and say, notwithstanding that option 2 has assisted with limiting the impacts and as we know is not contesting. So the pace we land is one that we're happy with. It's how far we need to go into the detail if it is an issue that you feel you need to consider, because we can't, for obvious reasons, assist you. We just haven't looked at it. If we were going to have time in, I don't know.
We couldn't do it.
7 days?
Yeah, at least.
I mean, we'd say we'd want to look at the model 7 days or something. I'm not urging that, because that I hope we can get to a point of saying landing position is we're all happy. But if it's a matter that you feel you need to deal with, it is a point of detail and one that you have to make an active decision in this case. And if you're interested, then we would like time to deal with it.
So if I may,
Council removes it.
well, yeah, I'm happy with either option, but the reason it's in there, I appreciate what you said about your position at the CMC, but it was a later email as well. We've got an email of the 8th of July 2025 from Mr. Steets, who I understand is one of the caseworkers at PINS, where he says an update from the inspector, and in the very first paragraph there, he says, I saw an email from the council asking how, given it's not drawn evidence, it should present the statement on how the proposed amendments made the proposal acceptable, particularly in relation to the economic implications. So we were conscious that you had raised this again even after we indicated on the 20th of June where we'd reached, as Mr. Hardy says, at the end of the day. So just to be very clear, that's why it is in. But I have no objection either. If you think you don't need it, strike it out, or 7 days for Mr. Fidget to put in whatever written response he wishes to make.
Mr. Fidget raises a good point. I don't know whether the model, do you know this? Is it a closed model? Do we have access to it?
It's publicly available.
So we could use that?
Yeah, absolutely, yeah. So you need to look at 2 documents. I've footnoted both.
Yeah.
It's the Kent SPD,
Yes.
which you probably already have a copy of, but if not, stick it into Google, we can provide it. And then if you look for the Orville, if you simply search for the Orville model, it's a publicly available model by the University of Exeter, and
Right,
you can
so
search it and click on it as you wish to do so.
Okay.
Given that I have identified the first main issue as the landscape and visual impact of the proposal, and I intend to deal with the impact on the use of the public footpaths under the heading of visual impact, and given the council's acceptance of the merits of option 2 and the impact that has on their position in relation to its acceptability, I am not going to delve into the matter of economic impact. So in that situation, Mr. Henderson, are you proposing to strike out
So,
paragraphs 29 to...
yeah, to be very clear, this is only in there defensively. We identified, and you've been frank this morning, sir, that you were thinking about instating an award of costs, and this was an issue you raised on a number of occasions. So we've simply acted defensively in respect of that to give you, if you wanted to, if you were, not wanted, that's the wrong word, but if you were minded to go down that direction, I'm simply trying to head you off.
Yes.
To be entirely clear.
Back me into a corner.
Well, not back you into a corner, so simply to head you off. If, however, as matters I think land today, the risk on that point is not one that you think you need to pursue, and instead you think the focus of this inquiry should be on that main issue as you've now formulated it,
Yes.
Such that I'm comfortable on the risk and you're comfortable that you're getting the information that you need on the focused issue that you've identified, then I'm happy for you to strike those through and not go any further. But it must be on that basis because I've got to protect my client's position.
I appreciate that. Well, I'll make it quite clear. I only intend to focus my reasoning on the potential visual impact
Well, I'm grateful then.
on the use of the public footpaths.
Well, so with that clarification, I'm very grateful. You won't therefore need to consider paragraphs 29, 30, 31 or 30, sorry, 29 through to 33, or even 30, the first part of 34. So in terms of 34, you would need to have in for completeness the final sentence.
Yes. Well, that goes to
Simply the fact that we've moved on.
visual impact and
Indeed, sir.
use.
Yeah.
Mr. Hardy, does that satisfy you?
Yeah, it does.
Mr. Hardy.
So the first part of this is really a summary of the administrative history, which I can take as read. I agree with what's been said by my learned friend. We get to paragraph 1.5. There's a quote which is just worth reading out. So that's from when considering option 2 on the 22nd of May of 2025. Elected members resolve that it can be concluded that the amendments to the proposal are sufficient to make the proposal acceptable. The Planning Committee were aware that this would form the basis of the Council's position at the appeal in relation to the amended proposals. The conditions recommended in the original committee report Appendix A would be provided to the Planning Inspectorate with minor updates where necessary to reflect the relevant updated drawings and documents. Just as an aside, sometimes in these cases you find that councils resolve not to object. That is a slightly different position, it seems to me, to a would support. So in this case, it's a would support the grant of planning permission. So my section 2, need for solar power. Why are we here? Well, solar energy generation remains a key building block of UK energy policy. That was spelled out by Ed Miliband, Secretary of State for Energy Security and Net Zero, in his ministerial forward to the Solar Roadmap, which was published as recently as 30th of June 2025 in the following terms. Solar is at the heart of our mission to make the United Kingdom a clean energy superpower. It's one of the cheapest and quickest to build power sources we have, and every solar panel we install helps us to take back control of our energy supply, protecting families, businesses and the public finances from the roller coaster of fossil fuel markets controlled by petrostates and dictators. That is why in our first weeks in office I reconvened the Solar Task Force to raise our ambitions for solar. So colourful language, but it's clear what's being said and the importance of solar to the government. So whilst policy support for solar farms is very long-standing, there's little need to go back further in time than the Clean Power 2030 Action Plan, which identifies significant beneficial impact for businesses from clean power, including price stability and market certainty, encouraging investment and job opportunity. The current reliance on imported energy also exposes the UK to unpredictable energy supplies and high energy costs, including for residents. When translated into planning policy, and my learned friend has already touched on this, but paragraph 161 of the framework states that the planning system should support renewable and low carbon energy and associated infrastructure and the transition to net zero by 2050. So that's the overall systemic support. And then specifically in relation to decision making, paragraph 168 provides, amongst other things, that when determining planning applications for all forms of renewable and low carbon energy developments and their associated infrastructure, local planning authorities should, and then quoting A, not require applicants to demonstrate the overall need for renewable or low carbon energy and give significant weight to the benefits associated with renewable and low carbon energy generation and the proposal's contribution to a net zero future. Later in these opening submissions and in the evidence of Mr. Fidget, we'll have a look at the potential differences, if there are any, between the use of significant weight and substantial weight. But in the framework, so far as it goes, 168A talks about significant weight. The PPG similarly identifies that planning for renewable energy is important, as increasing the amount of energy generated from renewable and low carbon sources will help to secure the national energy supply and contribute to mitigating climate change. The need for renewable energy provision is further reinforced within the national policy statements EN1 and EN3, although having effect for decisions on energy developments that are nationally significant under the Planning Act 2008, they can be a material consideration in decision making under the TCPA. This has been commonly accepted by multiple inspectors in recent decisions and is an approach which is recommended here given the significant size of this scheme. This farm would have a generating capacity of about 40 megawatts. Projected output of the development would result in a reduction of over 8,152 tonnes of carbon dioxide per year. The export capacity is calculated to provide enough energy to power about 11,550 homes annually. The development includes a proposed grid connection which sits to the north of the proposed substation compound within the site boundary at an existing 132 kV transmission tower. Importantly, a connection agreement has been reached with the network operator which will enable the proposed development to begin contributing to the network and the wider energy needs and goals of the UK. An agreed date of connection is proposed for 2029. National Grid have recognised the need for accelerated grid connection offers and have begun proactively working to bring forward the connection dates for permitted projects. Now, this plan is in collaboration with the industry, Ofgem and the UK government. And what I'm instructed by my clients is that 2029 is the kind of backstop. It may even be earlier. On any basis, it's important because there is a confirmed grid connection offer here, which means that there will be contribution towards the 2030 clean power objectives. The Council here declared a climate and ecological emergency in June 2019, announced a target to be carbon neutral as a council by 2030, as well as to address the ecological emergency, which is resulting in unprecedented rates of nature decline. There's an updated climate and ecological emergency action plan from 2025 that outlines the 7 key actions it will take to combat climate change to try and mitigate these negative effects on Swell and the rest of the UK. So bringing all those points together, look, this is a development which is certain, which will be built, and which will make a meaningful contribution to national objectives of clean power by 2030 and net zero by 2050, as well as chiming with that council declaration. So my section 3, planning policy, section 3.2 of the Statement of Common Ground sets out the relevant policies from the Bearing Fruits 2031 Swell Borough Local Plan. You can take those as read. Principal issues under 4, as well as receiving support from the Council for the proposed development. It's agreed there are no outstanding objections with the following relevant statutory consultees, and you've got the list there. So I then turn to the first of the issues, so landscape and visual impacts, Kent Downs National Landscape. Proximity of the appeal site to the Kent Downs National Landscape means it has been an important issue for this appeal, with the effects of the development on both the setting and the national landscape itself being points for consideration. I agree with everything that my learned friend said about the law. We've taken full account of the decision in New Forest National Park Authority. In that case, Mr. Justice Mould was Faced with a challenge by the National Park Authority to a grant of planning permission for a residential extension by an inspector on appeal, the authority alleged errors by the inspector in respect of his treatment of development plan policies, and of wider significance, the duty in section 11A1A of the National Parks and Access to the Countryside Act 1949. Section 11A1A imposes a duty to seek to further the statutory purposes of national parks, which include conserving and enhancing the natural beauty, wildlife and heritage of the national park. The duty previously required relevant authorities to have regard to those purposes. Section 245 of the Levelling Up and Regeneration Act 23 has strengthened the duty, as the judge observes, so that relevant authorities must now seek to further the purposes. So the special components, characteristics and qualities of the national landscape, well, they include dramatic landform and views, a distinctive landscape character, tranquility and remoteness. On behalf of the appellant, Mrs. Green concludes that effects on the setting would be slight to moderate adverse initially, reducing to slight adverse as proposed planting establishes. Views towards the national landscape in the vicinity of the site are limited by vegetation along the M2. As will be seen on site, there are some views up to Dean's Hill, but the gradual rise in the landform means that the national landscape isn't prominent in these views. Where visible, the development would generally sit below the gradual rising landform of the national landscape, therefore only interrupting views in very close proximity to it, not from more distant views. Looking the other way then, views from the national landscape are also limited by vegetation along the M2, along with fir wood and roadside hedgerows and trees. Where visible, the development would be glimpsed as a narrow band in the landscape, broken up by intervening vegetation, with substantial areas of built development at Sittingbourne visible beyond the site. Additionally, the proposed hedgerow and tree planting would provide further screening as it establishes. And in the evidence of Mrs. Green, she deals with this at her paragraph 3.4.11, so that's internal page 13. And there are three viewpoints which are singled out in particular. So they are viewpoint 7, viewpoints 15, and viewpoint 16. And I don't know whether you went to viewpoint 7. So viewpoint 7, Dean's Hill, there's a new build house called Swiss Cottage. And from there you can park in front of the property and you get a sweeping panorama. It's a 180 degree view. But I think the description that's given in that paragraph, in which I borrow for my openings, is absolutely right. The development glimpsed as a narrow band, broken up by intervening vegetation, with substantial areas of built development behind it. When you look at the landscaping along the M2, it's really extensive. And given the angle of view, we say the impacts are limited in the way that Mrs. Green has described. So viewpoint 7 no doubt will be of interest to you. In terms of the national landscape itself, Mrs. Green concludes the development would result in some localised moderate adverse effects initially, which would result in the medium to long term to slight adverse as proposed planting establishes. So the landscape character of the national landscape as a whole would not be affected. Proposed development would have very limited impacts on the special components, characteristics and qualities of the national landscape. Across the national landscape as a whole, those qualities would not be adversely affected. So, statutory duty, absolutely, that needs to be applied, but when you do that, the conclusions that I've just read out pertain. So, landscape character. Peel site has an open character, very large, intensively farmed arable fields. The neighbouring influence of the noise from the M2 affects tranquility. On each occasion I've been 3 times, and where you are in the field really is impacted by noise. It is not the sort of place where you'd want to sit out for a picnic, because the noise of the traffic at whatever time of the day I've been and whatever the noise, whatever the prevailing wind direction has been impactful. Presence of large agricultural barns at Vincent Farm and Sutton Barron Farm add to the perception of the intensive farming. To the north, northwest and southeast is a mixture of urban fringe and rural landscapes, which result in variation in the perceptual qualities from quiet rural areas to busy urban areas. To the southwest and southeast, the influences of the national landscape designation are evident. The initial gently rising land towards Deans Hill forms a transition between the non-designated landscape to the north of the M2 and the tranquil dry valleys and rolling rural landscape beyond Deans Hill. And just breaking off there, there was a comment in my learned friend's opening about the linkage with the national designation, and it's paragraph 22, where what's said is in Northwood's view, it's paragraph 22.2.2, in Northwood's views from the national landscape, the site contributes to a degree of perceived continuity between the designated area and its farmland setting beyond the M2 motorway. It's a matter for your judgment, but it seems to us that the M2 provides a harder stop than that. There's a real sense of kind of here-ness and there-ness. When you're in the national designation, it is different, but you've got the motorway, you've got all the movement, you've got the trees, and then beyond that, it feels different. So I think the appellant would disagree with that, Mr. Green no doubt will speak to this, but would disagree with that suggestion of perceived continuity, or certainly the strength with which that appears to be put in 22.2.2. So back to my text, 411, we're within the Swell Tunstall Farmlands landscape character area. Impacts on this LCA would be low, and when combined with a medium to high value would result in moderate adverse effects. Overall assessment of effects on the landscape character of the site assessed as moderate adverse due to the medium value, medium susceptibility to the proposed change, and medium magnitude of impact. As the proposed planting established, then effects on landscape character would become more localised, reducing those effects to slight adverse. Visual effects then, most prominent visual effects would be on receptors within approximately half a kilometre of the site. They would therefore be localised, and as you've dealt with solar farms before, 0.5 kilometres is really quite tightly drawn. The landscape strategy for the development designed to reduce the landscape and visual effects. It includes hedgerow and tree planting, as we know, to the site boundaries and along the public rights of way. Planting would help screen the development as it establishes, and there are some years and calculations there on what the effects would be. Planting would be retained once the solar farm is decommissioned. Public rights of way that run through and adjacent the site, along with the permissive toll ride, all are maintained as part of the development, and the routes enhanced by providing a minimum of 10 metre wide routes lined with hedgerows that would be created as part of the development. And you've got the note there from Mrs. Green. So visual effects would be substantial adverse initially, reducing to slight to moderate adverse as the proposed planting establishes. Where the routes run beyond the site, then effects would quickly reduce with distance. And the long-term post-decommissioning benefits of the wider routes would remain. So, next issue, best and most versatile agricultural land. Nothing in national planning policy or in the extant written ministerial statements prohibits the development of solar farms on BMV land. And what we have to say is this, that the 2015 written ministerial statement, that was made by the last government under very different circumstances. I'm not sure whether or not written ministerial statements ever get revoked, or whether they can get revoked, or whether they lie on file. This is not revoked, but you have to read that in the context of what's come out more recently, including the more recent WMS on solar and protecting our food security and best and most versatile land, dated 15th of May of 2024. And Mr. Fidgett's position is that much of that substance of the earlier statement has effectively been superseded. You also have to look at the direct planning policy which has been published, and there has been direct comment on how you treat best and most versatile agricultural land in documents ranging from the MPSs, so far as they're relevant, through to the solar roadmap at the end of June. There's a Q&A session in there about how those are treated. Planning policy and guidance, so notwithstanding all of that, it is clear that wherever possible, developers should utilise brownfield, industrial, contaminated or previously developed land. Where the development of agricultural land is shown to be necessary, lower quality land should be preferred to high quality land. If a solar project proposes to use any best and most versatile land, then developers are required to justify using such land and design their projects to avoid, mitigate and where necessary, compensate for any impacts. Compelling evidence should be provided. So we're not shying away from that. That's the guidance. In this case, just technically, we've got the ALC survey results, so mixture of grade 2, 38.2%, subgrade 3A, 50.9%, and then subgrade 3B, 10.9%. The site is therefore 89.1% BMV, 10.9% non-BMV. A point which Mr. Rose is going to raise is that there is a correlation between the subgrade 3B and the access tracks. So where the access tracks are, they are on the subgrade 3B land in the main. So with regard to food production, the proposed development extends across 2 fields currently managed in an arable rotation. Primary crop winter wheat, alternating with crops of oilseed rape, spring barley and spring oats. With the use of the 10-year average annual yield data, the yield contribution from the 2 fields has been calculated. Annual yield from each crop forms less than 0.2% of regional yield, yet less than 0.05% national yield for each crop grown in the rotation. Loss of these fields from food production will have a negligible impact on UK food production and therefore non-significant impact on food security. And you'll be aware, sir, we don't need to take too much time on this, but there's also been policy guidance in the form of the food security plan. There is the land use framework which has come out, and all of those documents over the last year. Everybody knows that renewable energy is going to take up land, but the government is consistently saying it is a small amount, and the solar roadmap provides that statistic and says, you know, in the scheme of things, it is a small amount. And I think there's a comparison drawn in that document with, say, the amount of land that's used for golf courses. So there is an expectation that it's going to take up farmland, and some of that is going to be BMV. During the 40-year period, proposal is to establish species-rich grassland under all the panel arrays. That'll benefit pollinators, insects and birds, promote other natural capital improvements, including improvements to soil organic matter, soil structure and overall soil quality. Following decommissioning, most of the land will have the potential to be directly returned to agricultural use, returning to its BMV status, and as I've indicated, we're going to have a soil management plan which is secured by way of condition. Decommissioning plan, retention of hedgerows, we've probably dealt with that already. I then turn to 423, objective of policy ST1 of the local plan, delivering sustainable development in Swale. Policy specifies the natural environment will be conserved and enhanced by using areas of lower quality agricultural land for significant levels of development. Incorporated a soil management plan detailing effective soil protection measures that would ensure soil functions and the services they supply will be protected and remain intact over the construction, operational and decommissioning phases. While the land will not be used for agriculture or all other ecosystems that the land and soil providers, such as supporting biodiversity, carbon storage and climate regulation, will remain intact. Land management strategy for the site will also support improvements to natural capital. So, there is a recognition. This is a solar farm like all the others. It will result in temporary loss of agricultural production, but it won't result in the loss of agricultural land or agricultural potential. And it can be considered that this development doesn't constitute significant levels of development and therefore does not need to be sited on lower quality land. Policies DM31 and DM20 place a priority on the protection of BMV, but recognise that a development may involve BMV land if there's no alternative site on land of a lower grade than 3A, or that use of land of a lower grade would significantly and demonstrably work against the achievement of sustainable development, and that schemes fully explore options for continued agricultural use and ensure that impacts on soils are minimised and mitigated to acceptable levels. So whilst there's no requirement as a matter of general law to produce an alternative sites assessment, let alone a sequential test, you'll be aware of the Bramley decision, a study was provided as part of the planning proposal, which was defined based on factors that included the prevalence of Grade 1 agricultural land to the northeast of the proposed site and the Kent Downs National Landscape to the south. That concluded that the appeal site remains the most viable option to meet the sustainable development targets of the project. So, because we say it doesn't involve significant development, will not result in loss of agricultural land potential, it represents, we say, a reasonable use of BMV land given the other priorities that must be considered locally. It's accepted that the development will result in temporary loss of agricultural production over the lifespan of the project, but the agricultural potential will remain intact. The proposals also support the diversification of an established farming operation and allow for the reinvestment of returns into the continued vitality and viability of that enterprise. They also address climate change, which is one of the biggest threats to farming in the UK, and that's something picked up in the solar roadmap, where the government says, well, look, one of the biggest threats to farming, actually climate change. They do so in an efficient manner, minimising the area of BMV required to meet the project objectives by the adoption of high-performing efficient technology. And then I've referenced paragraph 6.18 of the solar roadmap. I don't need to read that out again. Heritage, let's not forget that, just for legal purposes, section 66(1), of course, and duties. The proposed development would have an impact on the significance of the Grade 2 Sutton Baron House, Sutton Baron Hall. It's agreed that that would amount to less than substantial harm. It's mitigated by substantial buffer distance of retained agricultural land, proposed landscape planting of the temporary nature of the development proposed. So any harm to significance through impact on setting is therefore limited. Benefits, I'm not going to read these out because they're taken from Mr. Fidget's proof. You'll see those. Perhaps the only thing I need to highlight is the biodiversity net gains. That's paragraph 5.4. So the proposed development will deliver substantial BNG, option 2. That's 243.02 area habitat units, a gain of 197%, and the scheme would also deliver 36.62 hedgerow units, equating to 289.77% gain. And we say that should attract substantial weight. So, planning balance 6. Solar energy continues to lie at the heart of central government plans. It doesn't mean there's carte blanche. A planning balance has to be struck in the normal way. When it's struck, it's clear that planning permission should be granted. Starting point for site selection, availability of a viable grid connection in both capacity and physical terms, and as I've indicated, grid connection by 2029. We're outside of the national designation. We've referenced the statute duty again in 6.3 and can take that as read. Mrs. Green, as she'll indicate in her evidence, considers the setting of the national landscape purposes and potential impacts would be acceptable. 6.5 supported by additional landscaping, which supplements that already found along the M2 boundary, in which, as I've already described, is extensive. 6.6, this is an important policy compliance scheme which has been held up in the planning process because of what we say is politicised decision making on the part of the council, which ignored the advice of professional planning officers. But to its credit, the council has looked and reviewed option 2 and came swiftly to the view that it was able to support the scheme, and we're grateful for that. So it's a scheme supported by Clean Power 2030 and the Solar Roadmap, and will make important contributions to national objectives. So in due course we'll be requesting that planning permission is granted without delay. So those are my opening remarks. They're full, and can I just say this, that unless there is anything major which happens during the day, I'm not going to go over those same points in closing submissions. It would be additional points if I feel they need to be made. Thank you.
Thank you. Thank you. I think it would be, before we hear from interested persons, we'll have a short break and your first witness can set herself up.
Yeah.
Just one point where, and Mr. Fidget makes the point in his proof, and you've repeated it in the opening about biodiversity net gain. This is a scheme that is not required under statute to provide the 10%,
Yeah.
but the net gain figures have been produced and they are substantial. But the condition doesn't specify any particular figure. And I draw your attention to a recent decision by the Secretary of State where, and it's, I'll give you, the last 7 digits are 3347357. It's a data centre decision in just outside Slough,
Oh yeah, is it the Greystoke? Yeah.
Greystoke,
Yes, I know.
where the inspector, I hold my hand up to that, recommended that the Secretary of State attribute significant weight to the proposed biodiversity net gain. But the Secretary of State said, because the condition didn't specify any percentage and there was no Section 106 agreement, that she would only attribute moderate weight to biodiversity net gain. How much effect that has within the planning balance is a matter of judgment. But it was a point I'm going to raise, would have raised with Mr. Fidget,
Right.
in relation to the degree of weight.
I mean, I don't know the detail. I mean, that's a very helpful reference in that case. However, if there is an opportunity, we can talk to the council about inserting those figures so that there is an opportunity to afford fuller weight, then we will do that.
It struck me that, you know, the figures are based on the workbook calculation. It really depends on the nature of the implementation of that,
Yes.
as to what the outcome is. But if you were seeking to promote or continue to promote significant weight to the thing,
Yeah.
something would need to be placed within the condition, perhaps as a minimum. The scheme will provide as a minimum X percentage of BNG.
Right, well, that's very helpful. In the break, we'll talk to the council, but I think that would be a sensible move. Yeah. Thank you.
Pluck a number from the air, as they say. Right. Just coming up to 11:30. Shall we take 15 minutes, and that would give you a quick opportunity to have a discussion. So we'll come back at 11:45. Okay. either of you wish to raise before we?
Yeah, very quick. What time are you saying that should be?
Sometime towards 1. Have you somewhere to be?
Sorry?
Do you need to be somewhere this morning?
I didn't know what was coming in today, and I did not know it was going to be this long or what this is like and like that. So yeah, I really need to.
Right.
So Philip, we want pretty much knows.
Councillor Small, do you mind? I said you would go first.
No,
Do you-
please. No, I mean.
No, no,
I've
no.
pretty much got everything to say that I really need to say. When it comes to that. So carry on as you're looking at what we're doing, and
I'm happy to take you before Councillor Small. All right. Okay. Right. Councillor Small.
Thank you. Borden Parish Council still object to this application for a couple of reasons. First one is the development on the grade 2, 3, 3A agricultural land. It's inconsistent with the policy, local plan policy of DM31, which says that the development on best and most versatile agricultural land, specifically grades 1, 2 and 3A, will not be permitted. There's already been a large amount of agricultural land being used for development in Borden. So the cumulative impact on this shouldn't be underestimated. There's also been no evidence given that a suitable brownfield site is not available for this development. One of the largest threats to farming in Borden, in the parish, is development. We've had masses of development inside Borden with Wises Lane, with Manor Farm, and it's continuing for years. The second point is that obviously this solar farm will negatively impact on the setting in terms of visual impact, noise and light pollution, and also the countryside gap. The harm of this application far outweighs the benefits for the residents of the parish, even with the amended plans. Public rights of way have been closed at an alarming rate in the parish of Borden, with another 2 being closed just this week. In fact, I'm not sure if any, apart from on this particular site, if any of the footpaths are still open at the moment. These footpaths are being closed for 6 months at a time, keep on being renewed. We've had footpaths that have been closed for years now due to the development. So, yes, this application may be enhancing a public footpath, rerouting it, but the impact in the short term of this development on the public rights of way is going to be quite large. And again, shouldn't be underestimated. If this application were to be approved, Borden Parish Council asks that the following points are taken into consideration and, where relevant, controlled via conditions. All construction traffic should enter the site by Vigo Farm entrance, and no traffic should enter through the thoroughfare of Ode Street. An ecological management plan should be produced, a detailed one, in order to provide further details of the hedgerow planting on ongoing management of the site with regards to wildlife and the biodiversity. As hedgerows are being removed, we are concerned that dormouse habitat is being destroyed, and we would ask for the appropriate surveys and mitigation to be put into place. Restrictions on lighting to protect the dark skies during both construction and the operation of the site should be, in our opinion, should be put in place. And also a detailed construction management plan should be produced in order to provide details on access, working hours, wheel washing, etc. Thank you very much.
Just wait there. Mr. Hardy, do you have any questions or queries?
Have you seen the draft conditions?
No, they've not been made available.
Well, we need to make sure that you do, and hopefully that will provide you some reassurance. So the ecological management plan, the construction management plan, for instance, they're governed by conditions. So hopefully when you see that, that will that will help. That's all I want to ask.
Okay. Thank you, Councillor Small.
Have we got a
Mr. Browse, available?
Hello, yes.
Mr. Browse, if you'd like to make your contribution.
Thank you. Just get my script up. Okay. So I'd like to say I don't object to the proposal in principle. I've listened to all of the reasons why it should go ahead. And
Can I stop you, Mr. Browse?
Yeah.
I'm having difficulty hearing him. I think we need to turn the air conditioning down, and if possible, get the sound on the. Oh, that's a good start. That's,
Okay. Is that any better?
that's a lot better. Thank you.
Yes. Okay. Yes. So I don't have any objection in principle to the proposals. I've listened to all the things they've said and understand them all. But one of the things that has been mentioned a couple of times is the issue of noise. I'm greatly concerned that through the whole process, the issue of noise has effectively been glossed over. The noise which I'm referring to is the noise generated by the 178 string inverters, which are quoted as having something like 75 to 80 decibels. So what we're talking about is nearly 200 lawn mowers rattling away on a summer's Sunday. There's no indication at all that this has been looked at. I would say that the applicants know that it's possibly an issue because they commissioned extensive surveys and modelling to look at the issue of noise. And they've come to the conclusion they've tried to wash it away. They state that the potential noise is irrelevant due to the motorway. They also state that the houses affected should have double glazing and also cooling so that they don't have to have the windows open. Now, we live in a Grade 2 star property, much closer to the development than Sutton Baron, that's previously mentioned. And are we suggesting then that we have to install double glazing and air conditioning in that property to mitigate the noise? So what we'd be asking is that consideration be given to mitigating that noise by the development, not putting the onus on residents to mitigate the noise. Let the developer mitigate that noise. I can understand that it is possible to bury the inverters in underground enclosures and would ask that that be considered. So that's really what I have to say. Thank you very much.
Thank you, Mr. Browse. Mr. Hardy, do you have any?
Again, it's really a point of clarification. Good morning, Mr. Browse. Whether you've seen the acoustic technical note.
I haven't seen any new documents. I mean, are you saying now that you are proposing to bury those inverters?
No, no. It was the assessment that has been undertaken, which led to the position that's been adopted, is based on evidence. I just was asking whether you had seen that evidence.
I have read that evidence in detail, and I have to say, with due respect, I think that the conclusions drawn are very flawed. There's no indication in the surveys of any wind direction or barometric pressure. There's also no mention of how the type of noise is different to the motorway. It's a much more insidious and type of hum noise, which would be detrimental to the health and environment much, much more than the motorway.
And just in terms of your background, is that from a technical perspective, are you an engineer?
I am an engineer, yes.
Okay. And in terms of your knowledge of acoustics, do you work in that field, or what sort of engineering do you do?
No, I'm a mechanical engineer, but I am well used to looking at and analysing facts, and I've done that research, and I do understand that there's significant time and money being invested in these surveys, but there's great big holes in them.
Right. So in terms of the survey, you'll see from the note that
Have we got a CD reference?
it's in
CD 10.4.
CD 10.4.
Ten point four. Haven't got a 10. I haven't got a 10.
I've got it as a...
The appellant's evidence is CD 10.
That's where I've got it. Yeah.
Oh, right.
Yeah.
So, Mr. Prowse, in that note, in section 3, there is a table and it's headed comments response. Have you seen that?
I haven't seen that particular one. Now, perhaps you'd like to read that out?
Well,
There's a response about noise there.
it's a response to the points that you raised about noise. So what the acoustician did was look at your comments, and that includes things like the assessment being undertaken using the appropriate methodologies. So that's reference to BS 4142 2014, but also the ISO standard 9613. So the point made by the acoustician is, well, look, there are standard ways of doing this, and that's been followed. Do you accept that? Is it a problem that you've got with the standards?
No, the problem I've got is that, as you've mentioned previously, the survey was done over a period of 3 to 4 days.
Mm-hmm.
And I don't believe that 3 to 4 days is particularly an adequate duration, because having lived in the location now for some 15 years, I know that the type of noise generated by the motorway can vary enormously. Some days you won't hear it at all. In fact, what you'll do, you can potentially hear the industrial noise from Sittingbourne instead. And I've also walked some of these footpaths, and I know, for instance, that when you drop down below the level of the motorway, walking through the proposed site, there can be no noise at all on some occasions, because the noise of the motorway is effectively just going straight over the top of your head because you're down below it. So I'm just really questioning the dismissive nature of the report, and especially when it says that the houses should be insulated to BS whatever it is, which is completely dismissing the fact that there are 95 listed buildings within your own declared receptor area.
Mm-hmm. So can we just take it for the inspector's note? There's not a challenge to the fact that the assessments have been undertaken according to the relevant methodologies. That's agreed between us. What you are saying is that as a local resident, you take a different evaluative view of the type of noise that you say you experience.
I'm saying that there is not enough consideration for the effects of weather. There's not enough consideration for the positioning of the noise source, being lower than the motorway, and there's not enough consideration given to the insidious nature of the noise. And that may well be looked at correctly within the BS, but I'm absolutely positive that a constant low-level hum is far, far more damaging to health and enjoyment of the location than anyone can possibly explain.
Okay, that's helpful. Thank you very much.
Okay. Thank you, Mr. Bryce.
All right, thank you very much.
So, Mr. Wilmot?
Yeah, okay if I stay here and talk?
Oh, of course.
Yeah. I think follows on from Mr. Browse really is that some of the questions we've got about the noise that will be generated by the string inverters. I think in the email I made a mistake of calling them the transformers, but the string inverters and the number of them and the cumulative effect of that we have concerns about. Going back as well to what Mr. Browse said about the nature of the 3 to 4 days survey taken, that was looking, as I understand it, in February 2023. The prevailing wind is southerly, which means that the majority of the noise from the motorway is pushed northerly. There is a diagram that kind of shows a green, amber, red map of noise, which indicates that the predominant red noise level was actually identified to be on the south of the motorway, which would indicate that the wind on those particular days of the short spell of 3 to 4 days was northerly. So actually was not actually accurately representing the greater noise that we would identify more prevalently to the north of the motorway. And actually, you were saying about walking tomorrow, I would ask that you go to the south side of the motorway in the fields directly opposite Ode Street. There's an underpass, and maybe just gauge that yourself. I can't obviously say whether or not there will be prevailing wind at all, but more likely if it is, it will be coming from a southerly direction. And what you'll find is it's a lot quieter on that side of the motorway than it is on the north side of the motorway. So again, I'm a layperson, I'm not going to understand your terminologies, but understanding that there will be a likely presence of noise being carried from a southerly wind direction into the village itself and beyond. Aside of what we're saying about whether or not we should have adequate double glazing, etc., or air conditioning systems so we can close ourselves indoors, indicates to me that there is the likelihood there is a noise, and there is an insidious noise. And the question that I've got really to take forward for consideration is, we understand locally in Iway, the solar farm that was built had these string inverters buried, and it's not uncommon that they are. They must be buried for a reason, and the only reason I can understand that would be buried for is that they produce noise. And so people so the companies that are installing these have had to go to that additional cost and maintenance cost for a reason. It may be there is a reason other than noise. I don't know. That's our only understanding, is that that's the noise factor. I've got friends of mine that are involved in the renewables who do say they do produce a noise. And the cumulative effect of 178 may create a cacophony that adds to the low-level noise of the motorway. We choose to live in an area with a low-level noise of the motorway. That was our decision at the time. This should be understood as separate to that and given its own weight of consideration. And I'm not sure that, and again, you'll ask me questions, and you may assert, I'm not sure that the assumption that we all live with that motorway noise means that we are kind of going to live with the additional different noise, insidious noise of these string converters as they're operating, because we put up with the motorway noise. And I don't think that should be the same consideration. Just just to be balanced, because I do need to feedback as well. The footpath, the 7 to 10 metre footpath coming through the middle of I think they're 1, 2, and 3 and 4, across that traverses the field directly behind Ode Street will be an improvement on what we currently have, because the footpath we currently have is as wide as the quad bike that goes down it with the weed killer generates. So we do see that there will be an improvement for us living locally to access that, and I think that should be given due consideration as well.
Thank you.
Thank you.
Mr. Hardy?
Probably covered this already, but I don't know whether have you seen the technical note as well. I hope it gives some reassurance.
So the technical notes are technical notes. I think understanding that they generate noise, understanding that the cumulative effect of 178 of these will create noise.
Yep.
I'm not sure that I'm satisfied that there's an option to be taken or not taken to remove that element of noise generated by the solar farm. If it's there, and again, what happens if it does create noise that goes beyond your readings and your forecasted understanding of what that noise will be? What will happen then? Will there be any right for us to go to, when understanding how slow the processes are, to actually rectify what we would have to live with?
Yeah.
And I'm not sure that would be done to anyone's satisfaction locally, if at all.
So I hear the concern. In the note, the gap or the headroom between background noise levels and and what's produced, they're dealt with at paragraph 2.1.7 of the note. But the background noise levels are all receptors. The predicted noise levels from the solar farm are below those by more than 18 dB decibels during the daytime and then 7 decibels during the night time. So in other words, the motorway, the background noise levels is really the predominant noise source. So what's going on with the solar farm when you apply the methodology really isn't of concern. That's what the assessment is saying.
Yeah. The assessment with respect as well, if it's based on those 3 to 4 days, which that diagram indicates there was greater noise from the motorway on the south side,
Yep.
is not the predominant prevailing sound that we would hear.
Right. So
And
again,
I think that, and again, that goes back to what Mr. Browse was saying. The question is that an adequate survey to determine what the motorway noise is going to be? And it was actually then the reading taken predominantly to the south side of the motorway.
right. So again, similar point, that so far as the methodologies are concerned, there's an acceptance that they were applied, but you have a question mark over the sufficiency because of the choice of the days or the duration or whatever.
Yeah.
Okay.
And on that basis, I don't understand that my question and my concerns can be adequately answered if that's not occurred.
Okay.
And then I looked there obviously for the chair in the inquiry process with a far greater understanding of prevalence of noise generally with solar farms, to understand why it might be that certain applications include the need to bury those inverters.
Well, there will be different circumstances here. The prevailing noise is from the M2. So it might be in a quieter, presumably you'll accept this in a quieter scenario, where the impact of the solar farm may be greater. So the example you gave was that, there are other farms where people may do different things. Did you accept that they may be quieter background noise environments?
I accept all of that. I'm not arguing that. Okay. I'm talking about specifically our situation and where there is another background noise. The assumption seems to be that background noise will cover it, or that we are just somehow used to living with that background noise, which would mitigate any further cost or consideration to burying those inverters, which generate noise.
I've got the point.
Yeah.
Just in terms of use of the footpaths, and you're very fairly saying that there would be some benefit. I think you talked about the spray that was on, the narrowness of the footpath.
Yeah, that's right, yeah.
What sort of use is given to those footpaths? Are they... There's evidence of dog walking, so there was dog muck on the footpaths. Are they, from your experience, is that a local dog walking circuit, or how are they used?
Well, we use it every day for dog,
For dog walking?
yeah.
Yeah.
We pick up But yeah, we use that every day for dog walking. Other neighbours do. It's used considerably. It's used considerably for people that are walking on longer walks,
Yes.
local people. We see an awful lot of children coming through, or young adults coming through, who are doing their Duke of Edinburgh awards nearby. Occasionally we might see horses coming across it, but it's used every day. It's used every day by locals, and part of the reason we use it every day by locals is obviously we have a very busy road out front, so
It's safe to get the bread with.
so it's safer to be using the footpaths.
Yeah. So actually, that benefit that you fairly recognise would be a benefit to lots of local people because of the uses you've just indicated.
Yeah, no, yeah, absolutely. I mean,
Yeah.
that's I think I want to be balanced in what I'm agreeing to. What
You've been very
I'm
fair.
saying.
No, it was
And
just trying to get a
actually, yeah.
picture of what.
So actually, yeah. So the widening of that and the maintenance of that, to have something that at the moment it may be a metre to a metre and a half wide on a good year, depending on how well it's sprayed and how early in the crop process it's sprayed, to times when it's not, and you're just walking along a sheep path effectively.
Yeah.
So something that will be widened to that. Yeah, we see a benefit to that absolutely locally.
All right, that's helpful. I think I saw it yesterday. It's sort of laser cut, isn't it? Down where the spraying is. It's
Yeah, absolutely.
very sharp edged
Yeah.
on the
Yeah.
corridor. All right, that's helpful. Thank you.
Do you want to add anything?
Phil's pretty much said it all, other than we do spend a lot of time in our garden picnicking, if you want to say, barbecuing more so and everything. So locked up in my house with double glazing and stuff doesn't happen that much, but we do spend a lot of time. That's why we live where we live, and we've got a large garden, and so regards to sort of feeling you can shut yourself away to just get away from the noises and things like that. It's not part of what I live there for. So.
I think that's the points I wanted to raise. Again, it's about that living with that potential insidious noise, and once it's there, it's there. That's the thing that concerns us.
Okay. Thank you.
So I don't know whether you are intending to visit any residential properties, but we've got no difficulties.
Well,
if you want.
I haven't been asked, but I'm quite happy to visit any properties if I'm asked.
Depends what time you're coming through tomorrow, but possibly, yeah.
Well, I'm anticipating the site visit would start at around 10.
Okay.
And would that be a convenient time to visit?
Yeah, if you give me your details, I can come back to you later on in the day. Just in terms of trying to work it out, really.
I'm afraid if I give you my details, I would have to kill you afterwards.
Is that on record?
Well, unless you have an unfortunate accident between now and tomorrow, I might be a suspect. But
What time do I put the BBQ on?
what you could do is give your details to the council,
Mm-hmm.
and if you would just after 10 be an appropriate time to visit.
I'd have to come back to you on that. What we have is we run a dog boarding business, and we've got other people's dogs on the property, so we would need to make sure that was vacated to give you access to come in unfettered.
Right.
Well, you should probably use my place if you
Or
want.
use your, yeah.
I'll make some calls and move some work.
Yeah,
around,
well, we've got
push that.
option there, yeah.
So,
yeah, you could do that,
yeah,
couldn't you?
pop around there. I'll say, if you want to put the barbecue on, if you want.
Between the one or the other of us, we'll make sure that you've got access to
Right.
one.
So if you could give your details to the council.
Yeah.
And when we start the site visit, we'll go to your property first.
Mm-hmm. Yeah, it sounds good.
Yeah,
Is
okay.
that all right? So it would be...
I shall lock the wolves away.
And we live where Ode Street Farm is. We along that little row of houses along there.
But if you park there, you'll have to get permission from the farmer. Oh, he's gone. To park your cars there.
Right. So if you give your details to the council, we'll start the site visit with a visit to at least one of the properties, depending on
Absolutely, thank you.
availability.
Yep.
Is that all right?
Yeah.
Happy with that?
Yes.
Excellent. Right. So, Mr. Hardy, your first witness.
Yes, then I'm going to call Mrs. Lucy Green. And as you said, there's a summary proof, there's a main proof, appendices, there's the LVIA, which was written. Just to introduce, Mrs. Green witness particulars are in her main proof. So Lucy Green, BSc degree in landscape design and ecology, postgraduate diploma in landscape architecture, chartered member of the Landscape Institute, technical director at Wardell Armstrong, which is now part of SLR, and she leads the landscape team in the Newcastle office. 24 years of experience. We can read the rest. Is all that true and correct? I think there's a button on your microphone to
Yes,
press.
that's correct.
And have you complied with your professional institute's obligations?
Yes, I have.
Thank you very much. Now, this is a truncated evidence in chief. We're not going to go through all of it, but I want to pick out the main parts, if I may. So, in fairly quick order, in terms of the sphere of influence of the solar farm, so the most prominent landscape and visual effects, can you give an indication of the spatial extent of those, so how far they would radiate out from the development?
Yes, I've found them to be within approximately 0.5 kilometres of the site.
Thank you very
That's
much.
the most prominent impacts.
And you tell us you've worked on other renewable energy schemes, including solar farms, in relation to those other schemes. That type of visual envelope, or 0.5K, how does that correspond?
It's comparable to a lot of schemes I've worked on, but of localised impacts.
Thank you. So, landscape strategy, were you responsible for devising that?
Yes.
Okay,
Yes.
just give the inspector a thumbnail on what the purposes behind that was.
Yes, so we've proposed hedgerow planting to all the site boundaries, and then along the footpath corridors that run through the site, and there's some tree planting as well, enhancing the planting along the southern boundary to the M2, all to screen the development as the planting establishes, which would start to provide some screening within approximately 5 years, and then more substantial screening after that, approximately 10 to 15 years.
I was going to ask about that. There's sometimes debate about time it takes for planting schemes to establish, so just run over that again. So, so 5 years, 10 years, 15 years.
Yeah, I mean it's difficult to put a precise timescale on how planting will establish because it's down to weather conditions, and but there'll be a management plan in place to ensure that we can do all we can to establish it, to produce that screening as anticipated.
And in terms of where you get to at those 5, 10 year, 15 years, and then the commensurate reduction in impact, where do you say in terms of how many years going forward? Where would the point be where you say that the mitigation, is really helpful?
I would say 10 to 15 years.
Okay. What happens when the solar farm is decommissioned?
All that planting would be retained as permanent features.
One of the photographs, if we could just look at your main proof. So, the inspector will see this, or will have seen it already. It's a vast open field at the moment, but you've got a plate 1 on internal page 8 of your proof. And perhaps you could just read paragraph 3.3.1.
Yes. So, reason for refusal 1I states that the proposed planting would contribute to the harm by reducing openness. I've acknowledged that openness is a feature of the site, but I do not consider that the changes to this would be substantially adverse. Hedgerows, trees and woodland are characteristic of the area, and a review of the historic mapping, which is the older mapping is included in the core document 1.17 heritage statement. Shows that the site was historically broken up into several more field parcels. And then looking at aerial imagery, this was from Google Earth, on plate 1, shows a network of orchards and fields across the site. Therefore, the openness of the site is a result of recent agricultural intensification, and the proposed planting would restore landscape structure and habitat connectivity, which I consider to be a benefit of the proposed development.
That's helpful. And then you've got some further references in 3.3.2 to the LCA description. So sometimes it's said, well, if you're going to put hedgerows back and hedgerows with this, or the amount of hedgerows that are proposed here, that might run contrary to landscape character objectives. So in terms of what's been here and the type of field pattern that's been there in the past, what do you say? Would it be congruent or not?
No, I think it would help to restore that landscape structure that's been lost.
Okay, thank you. In terms of what's outside the site, so neighbouring influences, you've got the M2 and farming buildings and so on. Could you just give a thumbnail of that? What you say the characteristics are?
Well, as we said at the start, the site is very open character with large intensively farmed fields. The noise from the M2 affects the tranquility. The large agricultural barns at Vincent Farm and Sutton Barron Farm are prominent features in the vicinity of the site. And then beyond the site to the north, there's a mixture of uses of towards Sittingbourne and increasing in urban uses.
Okay. So to the south-west and south-east, I think it is, then you've got the Kent Downs National Landscape designations. Just in your own terms, can you just describe how you see the land and the transition between the site and the designation? Yes.
So from the south side of the M2, the land slopes gently up towards Dean's Hill, which is still large agricultural fields, and I see that as a sort of transition between the non-desert landscape to the north and the more rolling dry valleys of the national landscape beyond Dean's Hill to the south.
Okay, and just remind us, Dean's Hill, is that viewpoint 7?
Yes, it is.
Yeah, that's the view. Okay, so where does that take you to in relation to magnitude of impacts?
On the site itself, assessed medium magnitude of impacts and moderate adverse level of change. On the overall Tunstall farmlands, that landscape character area that the site is within, as that's a much bigger area, magnitude is low, but part of that does lie in the national landscape, so the value of that is higher, medium to high. Therefore, the magnitude of the impact, the overall impacts on the LCA would also be moderate adverse. And again, they would reduce as the proposed planting helps to screen the development, meaning making the impacts more localised to the site itself. And
if you get to that 15-year period, what's the
result? So my assessment brought the effects down to slight adverse. Okay.
So just looking then at the national landscape in a little bit more detail, what are the special components and characteristics of that national landscape which you say are relevant here?
Ones of relevance here, the dramatic landform and views, the distinctive landscape character and the tranquility and remoteness.
Okay. In terms of impacts then on of the scheme on those overall, can you just
overall, I assessed the impacts on the setting to be slight to moderate adverse initially, reducing to slight adverse as proposed planting establishes.
Okay. The views towards the national landscape, first of all. Just give us a thumbnail of that, what you see.
Yes, the views towards the national landscape in the vicinity of the site are limited by vegetation along the M2. You do get some glimpses up towards Dean's Hill, but the sort of gradual rise in the landfall means that it's not a prominent feature in those views. So I found that if you were in very close proximity to the site, to the development, there would be some interruption of those views, but beyond the immediate site boundaries, those views towards the national landscape would be retained.
Okay. Views then from the national landscape. So tell us about...
Again, limited by the vegetation along the M2. You've also got large woodland, fir wood, which adds to the screening from the national landscape. And where visible, the development, the site is seen as sort of narrow gaps in the landscape broken up by the vegetation along the M2. And then you can see beyond the site towards, there's long distance views towards Sittingbourne and a very varied landscape beyond.
In terms of the screening along the M2, how intact it is, how tall the trees are and so on, how would you describe it?
It's pretty substantial. There's a few gaps which we have proposed additional planting to infill in time.
Thank you. In terms of potential viewpoints from within the national landscape, look, let's not sort of shy away from them. Where would you be inviting the inspector to go? Almost to see the worst case. Where?
I think viewpoint 7 from Dean's Hill is the worst case. Mm-hmm. Viewpoint 15 is is a closer view, but it's a bit of a tricky one to stop at. Mm-hmm. And it's a glimpse view through one of those gaps in the vegetation along the M2. And then there's also viewpoint 16, which is more limited, similar to viewpoint 7, but the glimpses are much more limited at that point.
Okay, so we've got viewpoint 7, 15, 16, and I think they're the ones you identify in your proof.
Yeah.
Just in terms of characterisation, when you're driving into the national landscape, the inspector may well have done this, but how are the roads?
Narrow, windy, with tall hedgerows. So there are limited opportunities for views, such like viewpoint 7.
Mm-hmm. And if you were on foot...
So just when you say limited opportunity for views, limited opportunities of views of the site or limited opportunities of views of the wider national landscape?
Probably a bit of both, but yeah, limited views of the site because you are driving down quite narrow country roads with tall hedgerows along a lot of those routes.
Right.
So, just to pick up on that, so when you're within the national landscape, and you're trying to look at what you're saying is narrow lanes, and you've got hedgerows on both sides?
Yeah, in a lot of places.
And are the roads, are they the same level as the hedges, or are they set down? Are the banks? What's the...
Well, obviously, they'll vary, but they are maintained quite tall from what we've seen.
If you're on foot, one way of accessing the national landscape is to go onto the motorway bridge, and then you have the footpath which goes up the field, and then it forks off to the left. It may be that the inspector is invited to do that. What's your professional assessment of views from there?
Viewpoint, that's viewpoint 16. Well, if you're walking into the national landscape, the development would be behind you. So it's only really if you're walking north eastwards, and that path is very open. There are no hedgerows, so there's a continuous view. But the existing planting along the M2 is providing a substantial screen there. So I think my assessment concluded slight adverse the most.
Mm-hmm. Obviously, it depends on the time of the year and indeed time of the day. But when you've been, what is your assessment of the amount of traffic on the M2? Is it
It's always been sort of busy, moving. Yeah, it's a noticeable feature, even if you can see the cars moving and the lorries. Yeah.
And in terms of whether you see the vehicles, to what extent does that catch the eye or not?
It definitely catches your eye, yes.
Okay. So that's the national landscape. Then let's look at the public rights of way a little bit more that run through and adjacent to the site. Now, we've had some evidence from the local residents, very helpful. There's an accepted benefit in widening those. You produced a technical note, so do you just want to explain what you've done, if that needs to happen to the inspector?
Yes, so that note that we've just provided compares options 1 and option 2 as requested. I measured the points from both the sort of narrowest points and the widest points, which is particularly relevant to option 2. So ZR137, that's on the north-western boundary of the site. So there I've measured the point from the centre point of the path to the solar farm perimeter fencing and hedge, whereas the other paths I've measured more of the overall corridors that would be created. So yeah, ZR138 is the path that runs from Ode Street south. So you can see there, we've gone from 12 metres fence to fence to 16 to 26 metres fence to fence. And I've allowed 2 metres, approximately 2 metres for the hedgerows. And that's reflected through the other path, the ZR34, similar, 134, the similar. And then as we've already pointed out, ZR169 would no longer be surrounded by development.
Mm-hmm. I think one of the points made is that the way that through the fields, certainly the paths are sprayed at the moment. It's narrow, but it's really quite it's laser cut.
Very linear, yes.
Very linear at the moment. So even in the route corridors, are they going to appear in the same way, or is there going to be some visual variation?
Particularly the north-south routes, we've made wider areas and slightly narrower, still within the 10-metre minimum. So they would appear wider, grassier paths with the hedgerows on either side, and managed so that people can take a more sinuous route. Dogs can have a bit more freedom. So not as linear as the current situation.
Okay.
No. Just wait.
So
The end.
effects, we're almost there. So effects then on the users of those rights of way. Do you just want to summarise that?
Well, initially we've acknowledged that these would be substantial adverse because users will be close to the development without the planting. There would be views into the development, but as the planting establishes the assessment, I concluded that the effects were reduced to slight to moderate adverse.
Thank you. And then impacts on users of rights of way beyond the site. So what do you say?
Beyond the site, the effects would quickly reduce with distance. Again, I think viewpoint 7 is probably representative of most open views from rights of way beyond the site. Yeah. Okay. Viewpoint 4.
All right. So bringing all those things together, do you want to just summarise where we get to with all those points?
Yes. So my evidence and the LVAA that was been submitted has demonstrated that landscape and visual impacts of the proposed development would be localised and would be mitigated to an acceptable level as the proposed hedgerow, tree and woodland planting establishes. I do not consider that the landscape and visual effects on the setting of the national landscape and users of the public rights of way would result in substantial cumulative effects, as stated in the reason for refusal. And Swale Borough Council have now reviewed option 2 and concluded that had the amended plans been before the council, they would have been supported. Therefore, I see no reason for refusing the planning permission for Vigo Solar Farm on landscape and visual grounds.
You might get shot for calling it Vigo.
Vigo.
Vigo, as I understand it from the local. Is there anything else that you want to add? So that's a canter through your evidence, but is there anything else you want to add?
No, I think we've covered everything. Thank
Thank you
you.
very much. And that's a short evidence in chief, but hopefully that's enough.
Mr. Sewell, you
Yeah, well, there's two questions that come from that. One is about the maintenance of the footpaths for two reasons. One, because obviously we live there and we see what happens when the footpath isn't clear cut, is that people take shortcuts,
Yeah.
which could invariably be, unless it's fenced, while the hedgerows are growing, you will find that people will take shortcuts through the same farm, I'm sure. I can only say that anecdotally, but nature of people as it is, and we do see people cutting across the field, if the footpath isn't clear, and if it's not maintained, so we see that happening. People traverse across the crops, we will go out and say you shouldn't be doing that, and they'll say, well, where's the footpath?
Yeah.
So if it's not clear, people will take shortcuts, and if it's not maintained, are you then relying on locals to create those sheep paths, if you like?
Yeah. Well,
Through them, or how will that happen? Again, if it's not clear cut, people will stop
yeah, I understand.
using their own initiative.
Yeah.
and short-
Well, each section of the solar farm would have perimeter fencing
It is quick fencing.
with 2 metre high deer-proof fencing, so there would be no.
So that remains.
That would be in place from day one, and then there's a draft condition for a landscape and ecological management plan, which will specify the management of the grassland to the roots and to the whole site.
Second point, actually going back, because you were talking about the 10 to 15 years mitigation, you said about I'm just thinking about this as a 40-year project, and I'm going to go back to the issue with the motorway noise. If we're then projecting over 40 years that we're going to be moving away from diesel petrol engines to
I think noise is not really
no,
the ambit of this witness.
okay, so
Yeah.
Perhaps when it
we'll
comes to
come back that later.
when Mr. Fidget.
Yeah, it's just that projection of a 40-year project, and it's permissible to project the mitigation of the impact on it over 15 years. In 15, 20, 30 years, we're going to be moving away from fossil fuel, petrol diesel engines to quieter hydrogen and electric vehicles. Then there's going to be a reduction, I accept, in that background noise at the moment. Would that not need to be featured and mitigated into the 40-year life scale of the project, as opposed to current motorway noises, where predominantly they're petrol and diesel engines creating a lot of that noise? It's not this witness.
Yes. So potentially, Mr. Fidget will deal with that when he comes to.
I'm the first person who's ever asked that question. Pertinent, Thank you.
In all the inquiries I've dealt with on solar farms, you're the first person who's asked that question. I'll note that you're a forerunner. Thank you. Right. You mentioned the mitigation, and it was at section 3.3, and the aerial photograph showing the historic landscape and the nature of the fields and potentially hedgerows at that time. Is restoring landscape structure referenced in any local policy documents? Is it an objective of
It is mentioned in the landscape character assessment for Swale for the Tunstall Farmland LCA.
So which document would I go to look at?
Which one's that? Yes, 8.10.
CD 8.10.
Yeah.
I don't have a CD 8.10 on the electronic version. Is there an more up-to-date link?
Do you have the link that we set up last week?
When was that email? To the case officer.
That was sent on the 29th, so last Tuesday.
29th.
Around
Right, it's just
12:30.
right. I've got. Let's just.
Alternatively, if you just Google Vigo Lane appeal documents, it'll be the first hit.
Right. The link takes me just to CDs 1.
Do you want me to come around and just direct you there?
There was more than one reference to. CD 8. Well, it still takes me to one that says 8.9. 8.10. Right, I've got it now. So it's Landscape Character and Biodiversity Appraisal Supplementary Planning Document, Part 2. That's the one.
Yes. Yes.
Right.
So you get to page 46.
Sorry, page.
Page 46 for the
No, it won't open. Oh. It's just
do you want, I've got it open here if you want.
trying to open. So we're on page 46.
Page.
Is there a paragraph?
There's some bullet points, guidelines to conserve and restore.
So read it out, please.
The 7th bullet point says conserve the remaining landscape structure of hedgerows and shelter belts, woodland, former parkland trees, vegetated quarries and mature and mature and remnant orchards. Additionally, look for opportunities to diversify and restore such features to create more enclosed landscape, while additionally creating links between existing features.
Right. Okay. Okay. That's. Now the intention is to maintain the new hedgerows beyond the life of the solar farm. Your paragraph 3.11.
Yes.
Is there anything within the conditions that would prevent the farmer removing those hedges after the site is decommissioned and restored and returned to agriculture, as someone has done in the past, to enlarge the fields, presumably for agricultural efficiency?
No, there isn't.
Right. Okay. Right, and the final point. One of the concerns that's been raised by various individuals and groups is that the new hedgerow planting, particularly along the public footpaths, would create essentially a green corridor, or I think some people have referred to it as a tunnel of green that would detract from the attractiveness of the use of those public rights of way, and you've gone over some of these points. My initial impression of the immediate area of the site and the wider area of the national landscape is that, particularly, I'm only reflecting on the roads. I haven't been on some of the wider public footpaths. But there is a general impression of green corridors of varying width and bounded by hedgerows of varying density and height. So the question is that impression that green corridors of varying width and hedgerows of varying height are a feature of the local area and the national landscape? Is that a reasonable impression to take away?
Yes, I think it's probably more of a feature of the lanes and the roads where the public footpaths run through agricultural fields. They tend to be more, reflect like the position on site where the crop is seeded off on the route of the path.
So where green corridors would be created along the routes of public footpaths, your assessment of impact would be
Slight adverse once the slight to moderate adverse once the planting's established, because there may still be some views of the solar farm.
looking at the attractiveness of the pass and the amenity of the pass. What would be
I would say positive, yes. That's how we've designed them to be attractive, wide, open routes.
Okay, thank you very much.
Okay.
Coming up to 10 to 1, do you want a break for lunch?
Yes, that'd be good.
I think you suggested 45 minutes. Is that still your intention?
Sandwiches, so we're good. That's what I sent the client out for.
Right. So it's 10 to 1. If we take 45 minutes, come back at 1:35?
Yep.
So adjourn and resume at 1:35. Thanks very much.
Okay, thank you.
So, call the second witness then. That is Mr. Duncan Rose. So there's a summary proof and a main proof. And to introduce Mr. Rose to the inquiry, that's section 1 of his main proof. So holding a Bachelor of Science degree in Geography and a Master of Science in Environmental Diagnosis and Management, a full member of the British Society of Soil Science, and a Fertiliser Advice Certification Training Scheme Qualified Advisor. Associate Director at Wardell Armstrong for 2 years, leading the soils team in Cardiff. And then you've undertaken BSSS sponsored agricultural land classification training, and you describe yourself as being highly experienced in conducting ALC surveys and writing ALC reports following the Ministry of Agricultural Fisheries and Food MAF 1988 guidance. Is that all true and correct?
Yeah, that's correct.
We've got some more detail about your projects thereafter, and in 1.17, you tell us that you complied with your professional obligations. So you can take the rest of that as read. Similar thing to previous witness. This is going to be truncated evidence in chief, looking at the main points. But let's start with the ALC survey that was conducted by Wardell Armstrong and submitted as part of the planning application in April 2023. What did that show?
So the ALC survey found that the site comprised of 38.2% grade 2 land. That is towards the west of the site, within the western area of the site. That was limited. All the soils on the site are limited by droughtiness, and that was the best quality land on that side of it. 50.9% of the land was subgrade 3A, that's towards the east of the site, and there's a band of subgrade 3B running through the central part of the site. Again, the limitation of why that one is lower quality than the rest is because of droughtiness, and in that particular area, the soils there are slightly shallower, which does impact on the performance of cropping that could be got from that particular area.
Okay, so site therefore 89.1% BMV, 10.9% non-BMV in policy terms. Just in terms of the layout of the scheme and where disturbance for access roads is going to be, what's the where are they going to go in relation to the different grades of soil?
So where the tracks come in off Vigo Lane, they are entering into areas of subgrade 3B, so that's into the areas of non-BMV land, and they do go across the field margins into the areas of both 3A and grade 2 as well. So there is where there's going to be probably most of the traffic there, they're going to be into the areas of lower grades.
Can I just ask you to come a little bit closer to the microphones? I'll just pull that. Sorry, so where there is going to be most of the traffic, Mr. as you were saying?
Yeah, so the entry traffic into the site is around the 3B areas.
3B areas, okay, thank you. In terms of the capacity of the land then for food production, we've got development across the two fields that are currently managed in arable rotation. What are they grown for? Have you spoken to the farmer? What's your understanding about what's grown?
Yeah, so there was a calls with the farmers, the land managers there. The cropping there is predominantly in winter wheat, and it's got in a rotation of spring barley, spring oats, and oilseed rape.
Okay.
So most cropping cycles will have your winter wheat in a maximum of 2 years, and then they'll be going in with break crops within that rotation. So that would be usually in a spring cropping, or potentially in a winter oilseed rape that goes in.
Okay. So in terms of annual yield data, then you do some comparisons. I think you've got some annual yield data rates for the region. I think that's CD 9.2 yes. under your topic heading. Tell us about that and how what the fields, the yields from these fields, how that would correlate.
Yeah, so I've looked at a 10-year average for the particular cropping that was within that rotation that I mentioned. I've put it towards the mean of that. Usually when you've got BMV land, it would be sitting within
either above or just around the mean of that cropping. So we've got 10-year average data. That is in my proof of evidence.
That's your page 6, as I understand it. That's table 3.2.4.
Yeah, page 6, and goes on to further review of that data into table 3 as well, looking at the percentages of that. So I've looked at that in terms of in relation to the south eastern London region as well as the national yield. So the yield from each of those crops is less than 0.2% of the regional yields. Now that's looking, 0.2 comes into effect with the spring oats, but if you look at the other ones, it's much lower than that as well. So that's the worst case, is that it's at 0.2. So it's still fairly not significant in terms of the amount of yield that it's going to be taking. In terms of the regional yield, it's even the regional yield of 0.05%. In terms of the national yield, sorry, it's obviously a lot lower than that, at 0.05% for those croppings.
Okay.
And in case, again, that's 0.05 is in relation to the spring oats. The rest of them are significantly lower than that value.
Okay. So in terms of impact on food production, so far as these fields are concerned, and so far as these things can be metricated, what is your description of that impact?
I would say they would have a negligible impact on UK food production, therefore non-significant impact on food security.
Okay, thank you. So what's going to happen during the 40-year period, the operational period of the proposal? What is going to happen to the site?
So the proposal is to establish species-rich grassland under all the panel areas. So that's there to benefit pollinators, insects and birds, promote other natural capital improvements. Having a species-rich grassland promotes a range of benefits within the soil profile itself. So you've got a range of different rooting depths. So you've got large taproot plants that will be going a lot further into the soil, and you've got the grasses, which will have much more of a spread. So you've got quite a large, more than what they would have in a typical arable situation. They would have a much better rooting environment, improving soil structure and improving organic matter in those fields.
Okay, so that's during the period of operation. Following decommissioning, what will happen to the land under panel?
So during decommissioning, the hedgerows will be remaining in place. The land itself, if it's coming out of that species-rich grassland, if it's going into arable, there's some benefits there. You've got elevated levels of organic matter compared to what it would have been from its baseline condition, because of that, as I described, those characteristics of those species-rich grassland. So once you're putting a crop into that, it's got a better chance of providing you with greater yields.
Now, that was a question the inspector asked about. Well, look, you've got a period of operation of this scheme. Beyond that, the appellant wouldn't be involved in the farm anymore. Is there anything to stop the farmer from ripping out all of the hedgerows again? And the answer to that is no, but they would be in place. On the assumption that hedgerows were retained by the farmer, would there be any benefit to the farmland?
Potentially, yes. There will be increased number of pollinators that are staying within that area. So you've got more hedgerows surrounding those cropped fields. So that enables a better establishment of your crops. They also provide shelter. So those large areas of fields, as they currently are, if you do have high winds coming through, we're more often getting large weather events. We've currently got high winds in August that we don't normally, quite often don't see. So when you've got more areas, more like windbreaks, like you get from these hedgerows, then you can have better protection from stuff like lodging in the crop itself. So it helps the crop not fall when you're coming into harvest.
Okay, so can't control it, but there may be some benefits, and ultimately that would be for the farmer in due course. All right. In terms of policy, I think we've got ST1 of the bearing Bearing Fruits 2031, the local plan. I think that's at my reference CD 4.1. I think that's the plan. So policy ST1. Can you just explain what that is designed to do?
The policy specifies that the natural environment be conserved and enhanced using only areas of lower quality agricultural land for significant levels of development.
Okay. So, as we know, soil management plan is going to be subject to a condition. So in terms of compliance with that, so conserve and enhance, so do no harm or make better, what's your professional view in relation to the performance of this scheme against that policy objective?
Yeah, so with that soil management plan in place, you're going to be protecting how those soils are managed. So general trafficking around the site is going to be protected. During the construction, you've got soil handling restrictions, so there'll be stop conditions during wet weather to ensure those soils are protected. Temporary roadways going in with geogrids, examples of those sort of requirements will be all listed within that soil management plan. And storage locations, if there are areas of where there are areas where soils are being stripped, there will be designated soil storage areas, so that those areas can then be restored at the end. So it's a good with the use of that, you're able to retain the quality of that site.
Okay. So, whilst land, some of the land may be, will be under panel, what about the other parts of the ecosystem? So, hedges and so on, how are they going to be contributing towards fulfilment or otherwise of that policy?
Yeah, so as I said, you've got that increase in pollinators and that biodiversity. So you've got more organisms around. You're going to be providing. Sorry, can you repeat that?
Yeah. So in terms of the other parts of the ecosystem, so the land management strategy, what is going to happen during the 40-year period? How would the other parts of the landscape comply or not with policy ST1? So you've got, let me the question clear. So you've got soils.
Yeah.
You've dealt with that, and you say there'll be betterment in soils. In relation, we've got tree planting and the other parts of the landscaping scheme and the ecological management plan. That the policy test is it's set out in ST1, so delivering sustainable development. So would the land management strategy, does that help or hinder in terms of compliance with policy ST1?
Yeah, so with that soil management plan in place, the development itself will only result in a temporary loss of agricultural production, won't result in loss of agricultural land or agricultural potential in the future. So I would say that this development can be considered that it does not constitute significant levels of development to the soil. Therefore, those areas of higher disturbance don't need to be sited on lower quality land.
Okay, that's a slightly different point. So just in relation to that point on significant development, so that we can see from ST1, policy specifies the natural environment will be conserved and enhanced by using areas of lower quality agricultural land for significant levels of development. So, I mean, it may be, it's a matter for Mr. Fidget as well, but what's your understanding of that and how this scheme would comply or otherwise? Is this a significant level of development?
I would say it's not a significant level of development. No.
Okay. Policies DM31 and DM20 then, can you just give us a thumbnail of what they indicate?
So they both place a priority on protection of BMV land, but they recognise the development may involve BMV land if there is no alternative site on land or a lower grade than 3A, or that use of land of a lower grade would significantly and demonstrably work against the achievement of sustainable development, and that schemes fully explore options for continued agricultural use and ensure that impacts on soils are minimised and mitigated to acceptable levels.
Okay. So to the extent that it's a matter for soils and for you, there's an alternative site assessment, wasn't there, which was submitted as part of the plan proposal. Did that look at soil quality and ALC classification?
Yeah, so it looks at the surrounding areas. So to the northeast of the site, there's a higher prevalence of grade 1 land that occurs. And then if you're looking at areas of lower quality land, so areas that were mapped as provisionally grade 3, they actually extend down into the Kent Downs National Landscape Area. So that would come against other issues for siting the site within those areas. So yeah, there is a look at that. There's a higher grade lands as you move further northeast, away from where the proposed site is.
Okay, and your reading of that alternative site assessment then, in relation to the whether or not the proposed site was the most viable option or not, what was your understanding of the assessment?
I would say that the site still remains the most viable option to meet the sustainable development targets.
Okay, national policy then in the national planning policy framework. So those are the development plan policies. Can you just explain to the inspector what you take from the MPPF in relation to protection of soil?
Yeah, so the MPPF states that planning policies and decisions should recognise the intrinsic character and beauty of the countryside and the wider benefits from natural capital and ecosystem services, including the economic and other benefits of BMV agricultural land and trees and woodland. Okay.
How do you say the scheme complies with that?
So the proposed development result in the temporary loss of agricultural production from the land. So although the proposed development will result in temporary loss of agricultural land production over the lifespan of the project, the agricultural potential there will actually remain intact, and the land will be returned to its full ALC potential. And as I mentioned, with potentially increased soil health and yield potential for the soils there.
Okay. I think Mr. Fidgett's going to deal with the written ministerial statements and the 2015 and the 2024 statement. I'm interested in, so far as it's relevant to your expertise, what the solar roadmap has to say. So the solar roadmap from June of 2025, I think that's CD 618, I think it is. What do you take from that in relation to your expertise, your specialism on BMV?
Yeah, so that statement does go on to say that if solar projects are to use any BMV land, developers are required to justify using land and they're designed for their projects to avoid, mitigate, and where necessary, compensate for the impacts. So the proposed development that we have here, site is on the most viable option for the local area. Mitigation has been designed into the project with the inclusion of the SMP. So we've got the protection of the soil as the development goes through its lifespan, so that the land can retain its BMV qualities and retain that agricultural potential when we come to decommissioning. The adaptation of the species-rich grassland and creation of more hedgerows through the site can be thought as compensating the impacts of the development and ensures the soils are enhanced in their qualities to ensure a high yield potential of any future cropping.
Okay. We've then got the question of impact on food security, which we've looked at a little bit. Food security report, that's a government document that you do. Do you want to just explain what you take from that?
Yeah, so the part of the food security report concluded that long-term decline in the UK's natural capital is a pressing risk to UK food production. Both productivity and sustainability of food production rely on ecosystem services provided by biodiversity, healthy soil, and clean water. So for this project, the SMP is there. It has incorporated the land management recommendations from the Solar Energy UK's Natural Capital Best Practice Guidance. So it's taken measures from there. It's also taken measures from other more wider guidance on soil management. Mm-hmm. This guidance identified and provides practical guidance on how to protect, optimise and improve the natural capital services from the land used for solar developments.
Okay. If you didn't do anything, you've seen the kind of scale of agricultural practice, the sort of thing that's going on the fields at the moment. What's your take on that if that intensive arable production were to continue?
Yeah, so if the site was to stay with its current cropping rotation, it does have an impact on soil quality. That if they're not bringing in regenerative agricultural techniques and they're carrying on with standard techniques they'll be potentially seeing a reduction in organic matter over the years. So we're going a decline in soil quality as that type of cropping rotation continues. By having the solar in there and having the land going into the species-rich grassland, it enables the soils to be sort of have a rest period and be able to build up on their soil organic matter levels.
So if you convert arable land to grassland, what's your understanding of the effectiveness of that, of increasing natural capital such as organic matter or and impacts on soil structure? Is that a good thing to do and a good way of doing it?
Yeah, it can be. Yeah, so a lot of farmers are now looking at putting grass into the rotation, so they will have a couple of seasons of grass to build soil structure back.
Okay.
So this will just be a longer term version of that.
All right. Pure policy matters. I'm going to pick up with Mr. Fidget. Is there anything that you feel I've missed that you want to add in your evidence in chief?
No.
Good. All right. Thank you very much.
Thank you.
Does anyone have any questions? Okay. There's a variety of soil quality across the site. 3A, 3B, grade 2. My understanding is that when the farmer is looking at the various fields, it's cropped on the basis of the best quality land within that field. So on the grade 2 land, where there's 3A and bits of 3B, he or she would crop the field on the basis of that it was grade 2 land.
Yes. Yeah. So
there would be an impact on yields across the field, but generally it would be cropped on the best quality classification.
Yeah. So they have the potential to get the best quality yield and the highest yields out of those fields because due to the
given that approach, why should I not treat the whole of the site as being best and most versatile agricultural land, grade 2 and 3A, and the loss to agricultural production for the 40 years and the weight that I would attach to that?
So in the ALC system does allow you to incorporate areas of lower grade into areas of higher grade. But this is usually when you only have isolated points. Where we've got multiple points going through, it's shown that is a distinct area that is going to be producing lower quality. So it would be best practice to map it as being non-B and V in this case. In for these particular soils, they are limited by drowsiness. In those areas, the farmer may be seeing yield penalties in those areas due to drowsiness in that crop. So it could be an area of the field that they know is not going to be performing as well.
The intention is that the land would be put to grass for the 40 years.
Yes.
Is there a reason why as with other solar farms, there is the land in and around the panels is used for grazing, particularly sheep. Is there a reason why here the intention is not to use the land for grazing?
It's usually down to the availability of grazing livestock in the area. I'm not sure on the history on what the decision was with regards to the land management. I believe there may not have been a grazing flock within the vicinity to make it viable.
There's no history about sheep, and actually it's a specialised job. Yeah.
I've been given to understand that there are people who go around the country and will put grazing flocks on solar farms. Not necessarily are they related to the immediate area, but they look for areas within solar farms to graze flocks. Is that a misinterpretation that I've been given?
I have seen it on projects. It's usually have contracts being written with that grazier to make sure that they will be coming into that land for the duration, or have someone will come in after their contract has ended, so it carries on throughout the lifetime. So there is that option. I'm not sure if it was viable in this case.
You talked about significant loss, and you said you didn't consider this proposal would be significant. What do you define as significant in terms of the amount of land that would be lost, even for the temporary period?
If you go back, if we're looking at significance in terms of the IA and IEMA guidance, the first level of significance comes in at 5 hectares, going up to 20 hectares, which becomes the high level of significance.
So here, would the nature of the proposal not result in significant loss, albeit for a temporary period?
It wouldn't go into the category of significant. The areas of substation and trackways, check what there. Sorry, I don't have the figures to hand for those areas.
So, but what would you describe as significant? We've got 52 hectares.
If you had large areas of hard standing and those soils were being stripped out and not necessarily stored on site, that would be a significant level of disturbance and significant level of development. The site has a relatively small substation and access tracks, and the arrays themselves have little disturbance on the soils.
Okay. That's it. Thank you very much.
Okay, thank you.
Do you want a break or do you?
No,
No.
we're all right there.
Right.
So, Mr. Fidget. So, Stephen Fidget, you are a member of the Royal Town Planning Institute, your BSc degree in Town Planning Studies and Diploma Distinction Level in Town Planning. You're a member of the Institute of Materials, Minerals and Mining. You're a Director of Union for Planning Limited, which is an independent planning consultancy based in London, which you helped to found in 2017. Prior to that, UK Head of Planning at WYG, White Young Green, now Tetra Tech, which was a multidisciplinary consultancy, and before that, Managing Director of Alliance Planning Limited, prior to its acquisition by YWG. 35 years of experience. Is that all true and correct?
Sadly, it's a long time, but yes, it's all correct.
Very good. You tell us why Mr. Mulvaney is unable to appear, just so there's no mystery about it. He's getting married today. It's actually his marriage. It's
He
his
is.
wedding day today.
He is indeed,
and
we wish him well. Yeah.
We let him off. Ollie sends his best wishes. Right, in terms of professional, your professional commitments to the organisations that you belong to, have you complied with those?
I have.
Okay, you've got a summary proof, you've got a main proof, again, truncated evidence in chief. We're going to pick up on just some of the points that are remaining. I'm going to start with some policy and two matters there. Firstly, Mrs. Green was asked about policy support for reintroduction of hedgerows. So landscape, the landscape structure. Is there a policy in support of what is being proposed here?
There is, and there is in most local plan documents. In this case, it's policy DM29, which provides express support in the local plan for both the retention of existing traditional hedgerows, woodlands and trees and related features, but also the reintroduction of those where that can be achieved through development applications.
Okay, so we've got the landscape character assessment. We went through that with Mrs. Green, and then that's translated into planning policy, and that through the vehicle of DM29.
Absolutely, that's right.
Next question is DM30, and we just had a look at that. The inspector just asked a question or two on that of Mr. Rowe. So DM30, can you give us your evidence on that, please?
Did you mean 31?
Sorry, DM31, yes.
31, agricultural land.
Yes.
Yes. Yes. So essentially, it's a policy that reflects national policy. Seeks to ensure that development's only permitted on agricultural land where that's necessary, and that development on best and most versatile agricultural land isn't permitted other than in a number of specific circumstances. The first of that is the land is allocated, which clearly isn't the case here. But the second part is that there's no alternative land of a lower grade that could meet the development objectives. And the third one is that the development would not result in the remainder of the agricultural holding becoming non-viable or lead to other losses of BMV land. So in this instance, we comply with those second and third parts of the policy, and therefore we comply with the policy as a whole.
Thank you. There was a distinction, I think, drawn by Mr. Rose between permanent loss, and he was looking at the areas that might be under the substation and under hard standing, and then the temporary covering of parts of the fields with panels. So in relation to the test policy ST1, when that talks about significant levels of development, and then the policies in relation to BMV, what do you say? Is that what are the policies trying to do? Are they looking at total loss, or are they looking at a temporary reduction in availability of soils?
So the fundamental purpose is retention of long-term agricultural potential, and therefore retention of long-term quality, which this scheme does, as Mr. Rose was outlining. I think so. You asked various questions about, is the temporary loss for 40 years significant? Well, in some cases it could be considered in policy terms to be a significant period of time that there is a loss, but that temporary loss occurs in agricultural terms through set aside, through all sorts of other things. In this instance, that loss is to essentially a species-rich meadow, which has a beneficial function in, as Mr. Rose was outlining, in terms of reinstating some of the soil structure and quality that long-term arable does erode over time. So I think, my view is that we're consistent with policy. There isn't a significant impact. The question arose about livestock grazing in the meantime. I've been certainly involved with schemes where that has occurred, where you've got mixed farms, for example, and you've got animals that are available to do that. This is an arable farm that doesn't have those livestock available, and therefore, unless you've got the buildings, the infrastructure available to deal with livestock, it's not a practical proposition.
So in this case, are we proposing to have livestock or not?
No.
Okay. In terms of benefits from the scheme, and we can unpack a few points here. You deal with these in your planning balance section of your proof, which is section 8. So that's internal page 42 of your proof. And immediately, I want to pick up a point that I flagged in opening and said you would deal with, and that is in the MPPF, paragraph 168A, the government talk about the attribution of significant weight to the benefits of renewable energy schemes. In your planning balance, under a number of headings, so you can take any of them, but energy security, you attach substantial weight to the potential benefits of the appeal scheme. So I'd like you to explain why you, in knowledge of 1688, why you have used that language and how that correlates with what the government says.
Yeah, I suppose I dealt with it very briefly in my evidence in para 8.8, where I set the semantic scale that I have used then subsequently within the evidence, and I did that for clarity, really. I'm conscious that in some previous appeals, there's been a lot of debate about the difference between substantial and significant, which can get quite tortuous at times. In my mind, that's why I set it out at 8.8. Substantial and significant are effectively the same thing, and that's what I've used going through. I've not sought to distinguish one being higher weight than the other.
So you aren't looking at something that's significant or not significant. What you're doing is looking at you provide a scale, and the way that you've used those terms is set out in paragraph 8.8.
That's right. And that's in past experience, whether something is significance is perhaps confused relevance with the weight that should be applied. So right. I've always stuck to substantial, moderate, limited, or no weight. Okay.
So the MPPF talks about significant, and the inspector will have to look at that carefully because that's what the government has to say. Where on a scale, so top, middle or bottom, do you say significant would be, as you understand what the government is saying?
Substantial.
Right.
That's the equivalent.
So at the top of the scale, you're using
at the top of the
substantial,
scale, yes.
Right? The government is using significant, but it's not that you don't see a difference between the two.
Yeah.
All right. In relation then to the benefits as you see them, these cover a lot of areas. So you might say the need for renewable energy, energy security, and so on. If it was said to you, look, you are potentially double counting because these are all renewable energy benefits flowing from a solar scheme, what would you say?
There's certainly an overlap, but I would clearly distinguish things like energy security from the zero carbon agenda. Energy security is provided by having domestic sources of energy production. It de-risks the UK from global markets, particularly in oil and gas and other things. And that is that's certainly achieved by the development of UK focused renewables, but it is a different policy objective. The development of clean energy and renewable energy is a policy objective in its own right that also happens to achieve energy security. But you would pursue it, irrespective of your agenda on energy security, you'd pursue it anyway because of the need to tackle climate change and achieve a zero carbon economy.
Yeah, and to make that point, it might be helpful to look at the solar roadmap. In my opening submissions, I referred to the ministerial forward, where the Secretary of State had to say this, and I'm repeating what I said, but solar is at the heart of our mission to make the United Kingdom a clean energy superpower, one of the cheapest and quickest to build power sources we have, and every solar panel we install helps us take back control of our energy supply, so protecting families, businesses and the public finances from the roller coaster of fossil fuel markets controlled by petrostates and dictators. Is that about security or is it about climate change?
It's about security primarily.
Okay, so you've got security, you've got climate change. I think in your planning balance, the first they're dealt with in that way, in that order. So you've got energy security first, you apply substantial weight. Then you've got clean energy and renewables, to which you apply substantial weight. And then I think we can leave out social and economic benefits for a second. Over the page at 8.26, you've got environment and climate change, where you sort of refer this back to the declared climate emergencies at the UK level and at Swale level. What's that about? Is that the same thing, or is there a nuance there?
So there is a nuance, and this is where there is probably a greater degree of overlap here. But this is more about the actual environmental impacts of climate change and dealing with that, and how you design individual proposals to achieve multiple benefits across that environmental agenda, whether it's minimising the impact of flood risk, archaeology, ecology, air quality, all of those things that go part and parcel of achieving what is a beneficial environmental outcome, and at the same time delivering progress towards tackling climate change.
Okay. So you've teased those out into three strands. Whether or not the inspector wants to telescope those perhaps into two, we'll leave that there.
Yeah.
If you are going to have a fair balance so that you are comparing apples with apples, is it also then right to tease out the harm? So for instance, if you've got landscape and visual harm, is that just one, or is that actually, should that be landscape, visual, and say recreation?
It probably is too. You can break it down in a way in this instance. I've in the summary table at the back of this. In fact in the text I talk about visual and landscape. But then in the summary table at the back, I've combined them simply because they both start at moderate, reducing to slight. I've given them a weighting of moderate.
Yes.
So I've sort of elevated them by combining them.
Well, the question I'm really asking, it's obviously your evidence, the way you do it, but it's what you're asking the inspector to do to make sure that you've got a planning balance that is fair. So it's
Yeah.
apples with apples, rather, you know, telescoping
You
on
could.
one side of it, not on the other. That's what I'm asking you about.
Yeah, and in the in the text that's certainly gone through in terms of each element that Mrs. Green has referred to, both in landscape and visual terms. I've concluded at 849 that I attach moderate weight to the adverse impacts on the landscape and visual impacts that result.
Okay.
So if you were to unpack that, you could say, well, that's moderate weight to landscape, it's moderate weight to visual.
Yeah, fine. Okay, well, that's helpful. Social and economic benefits, then, that's your paragraph 819, then you give moderate weight to. Biodiversity net gain, I think you give substantial weight. In the break, have you negotiated a suitable condition to, which includes the metrics?
Yes, so I believe that Mr. Oates is about to or has emailed pins with some wording that has been added to the landscape and ecological management plan condition to deal with that.
And what does that require a minimum level?
It requires a minimum. It is set slightly below the figures that were talked about earlier, just to ensure that in the detailed design process there is a degree of flexibility.
Yeah, some rigour.
But there's still very substantial net gains.
Okay, that's fine. Then on the harm side of the equation, then we've looked at L&V, and you can separate that out into landscape and visual, as you've just indicated. You've got moderate weights for those. BMV, you've got limited negative weight. This is your table at 8.62. We've already been over that. Public rights of way, I think limited.
Indeed, and I think on that, I suppose, picking up the various contributions that have been discussed earlier, there is obviously a short-term negative impact in terms of certainly the perception of panels and development within the site, but long-term, the benefit of reintroducing hedges, trees, and other things to that landscape, I believe, would enhance that recreational experience. And I think that the width of the recreational routes we heard this morning was something that was recognised.
Yep. Heritage then, separate consideration. Of course, we've got the statutory duties to be bothered about. So paragraph 8.50 and 8.51 of your main proof, you reference the wider settings of the Grade 2 listed buildings, Sutton Baron House and Sutton Baron Hall. So how does that translate into policy and weighting?
That's right. So less than substantial harm in policy terms. I think it's at the lower end of the scale in that sense. Looking at the context of it, the development has been set substantially away, substantially south of both of those buildings that all form part of a complex on the other side of the more modern farm complex, and with the landscape screening that we've got, I consider that limited weight in harm terms should be given to that in the planning balance.
Okay. We've talked about noise, and this is a separate point that was raised about the electrification of vehicles. And you recall a point was put, well, look, the noise surveys might be assessed against ICEs at the moment, but during the 40-year lifespan of the scheme, there may be a move towards electric cars and HGVs.
Yeah.
What's your... I'm appreciating you're not an expert acoustician, but what are your views as a planner from your drawing on your general knowledge?
And I drive an electric vehicle as well, so I have personal experience of that. What you tend to find, and we do a lot of, or I work with a lot of acousticians that deal with schemes close to major road network, and the predominant noise, it tends to be the nature of the surface and the interaction with tyres on that surface, which obviously reflects the weight and speed of traffic travelling on that surface. Yes, you do get, as I think past the council offices at lunchtime, noisy vehicles where you get the boy racers with silencers taken down and things like that, but you may not get those in 20 years' time. But they're the exception rather than the rule. So I think in that sense, the noise level, in my judgment, is not likely to change significantly. But as of today's date, we have to base decisions on the British standards and the methods that are adopted that the EHOs have considered, and they find that acceptable.
And what about degree of headroom?
So in this instance, we've got an awful lot of headroom. It's very substantially below the existing prevailing noise environment, both during the daytime and at night time. So there's an awful lot of headroom for change. Should I be wrong?
Okay. Just a bit about the national landscape, and we can probably wrap in the use of the footpath network. You've been to the site.
I have.
What the footpath, as the inspector will do. Your perception of the environment. One of the qualities of the national landscape is tranquility and remoteness. What's been your understanding or your impression of the site and of your experience of the rights of way?
So in that sense, the site exhibits a real presence of the M2 and the noise associated with it. It's not what you would describe as tranquil on any of the occasions that I've been there. The noise level does vary from time to time with prevailing wind directions and traffic and rush hour and things like that. But it's not peaceful or tranquil. It's a route that is functional in some senses, because if you're one of those Duke of Edinburgh or longer distance hikers, you pass through it whilst heading into the national landscape. If you're more local, you're doing it as a dog walk or something like that. It's not somewhere where you would dwell. And having dealt with a lot of rights of way networks over the years, it's something that can be improved, and I think the landscaping and the routes that we are proposing do significantly improve it and reduce the potential visibility of the M2, not necessarily the acoustic qualities.
Okay. In terms then of the impacts on the national landscape and its setting, you've driven around the area and you've got the evidence of Mrs. Green. I'm interested in your view as a planner, your experience, professional, your view of the effect of the M2, whether or not there is that sense of continuity on both sides of the motorway or not. How do you perceive views out from the national landscape?
My perception, and I suppose it struck me first time I visited the site, is that the M2 forms a sort of a dividing line between the rolling landscape to the south of the national landscape, where the land rises, you're into the downland features, and the flatter sort of estuary sort of style of landscape that is to the north. And in that sense, there is farmland both sides of the M2, so there is a degree of continuity in land use terms, and you do perceive that. But that land to the north is much more closely associated with human habitation and all that entails.
And if you were to go to viewpoint 7, which we're going to encourage the inspector to go back to, that's in the evidence, that's that kind of panoramic view. What did you see? Through the planner's eyes, what was your impression? So
you see, it's a very pleasant view. It's a view that the the residents of those houses there no doubt enjoy. You have a view in the foreground over rolling agricultural landscape with fields, hedges, trees, woodlands. You're then aware of the M2 across, running from sort of left to right, and the landscape of the Sittingbourne and the land that frames the estuary to the north, with wind turbines to right and left. You can see shipping out in the, on a good day, out in the on the water on the Thames estuary. So you see all of those things, and actually that's I think it's a positive in that view, that you can appreciate all of those things. Our site is as you referred to earlier, a sliver in that landscape through one principal viewpoint.
Okay. Thank you very much. I think we've dealt with the statutory duties, and the nature of that are agreed between ourselves and the council following the New Forest case. That's all I want to ask you, I think. Mr. Fidget, is there anything that you think I've missed?
No, I think you've covered most things.
Good. That's evidence in chief. Thank you.
Do you have any questions?
No, just thank you for taking time to consider the question asked about the relevant noises over time. The only thing I'd say for the chair is that may need to be looked into for other future planning over time. The surface development of motorways will also change over time as well, and improve the tarmac code, and it's due resurfacing.
Yeah.
Long stretches of that anyway, so you might be listening to on the tarmac, which you do know is the material going down.
Yeah, I think.
Thank you for that. Right. Just one, everything, a lot of stuff's been covered. Just want clarification on at paragraph 4.17, it's the connection to the national grid. There's a reference to the anticipated connection and then full transmission scheduled for January 2029, and then there's a reference this morning about it could be sooner rather than later. So what do the two dates mean? Can you explain the two dates?
So I think the January 29 date is effectively the date that the site could begin export. That's my understanding of it, because that's the date when all of the works to both the network and the site could have been completed. That's the committed date. It potentially could be earlier if those works are commissioned earlier.
So what weight do I put on the October 27 reference as opposed to the 20?
I think I would put weight on the 2029 date as the date that it could begin export.
Okay. Finally, it's the alternative sites assessment, and it's referred to at 658. It's this 3 kilometre reference. Connection point after that it becomes unviable. 3 kilometres has been mentioned to me before in various inquiries in relation to solar farms or battery storage. But I've also come across someone mentioning 8 kilometres. So where does 3 kilometres come from? Is this an individual operator's criteria, or is there something somewhere which
I'm not aware of a hard and fast published rule that says, or standard that says 3 kilometres is the be all and end all of it. The point about viability is, I think it depends on both the scale of the project and the consequent distance over which you can make those changes without unacceptable transmission losses or the scale of the investment being unacceptable for the project. For a project of this size, the 3 kilometres is a typical radius to look. I have to say that most of the sites that I've been involved with, it's been a lot less than that, and actually it becomes problematic, if you do get to that sort of distance. And that's partly practical terms and but also viability terms.
Right. Okay. Thanks very much.
That's it.
Thank you.
Yeah, those are questions we've got.
Do you want a break before we move to conditions?
Yeah, do you want just short break?
Great, just so I can grab printouts of these condition updates.
That would be good. Yeah.
Excellent. Right, shall we take... come back at 5 to 3. Is that all right?
Just the two conditions rather than the whole plan. Yeah, I've got enough copies for everyone.
Just because if we're going to have a break, I don't know whether you were able to print them off.
Well, I can see them here on the screen,
Right,
so
okay,
the additional conditions.
I've also asked someone to put them out and leave it in our rooms.
Oh, amazing.
Just grab them,
Right.
bring them.
Cool. Right? So I'm not going to go through each individual condition as they're proposed. I've just got comments on some.
Before you do that, actually, I'm going to just hand out these condition updates.
Thank you very much. Yeah.
Have you found the conditions on the core
No,
document?
I haven't. You sure?
Is that the full set? Or?
That's right, so we'll share. You sure? Yeah, no, don't worry.
Okay.
Something might access to the Wi-Fi drops out. No problem. Thanks for
Thank you. Right.
I don't have a spare set of the update.
The 5-year time limit, condition 1, that's to account for the 2029 connection,
Yeah.
so that the permission doesn't run out.
Correct.
Okay. 5D. 5D. That's right, D. Oh, yes. There's reference to the post-excavation assessment report being in accordance with Kent County Council requirements and include. It struck me as that bit is vague. If the requirements are contained within a specific report or another document, it would be better to specify the document rather than Kent County Council's requirements.
Sorry, you go for it.
With Part A, it requires the field evaluation works to be undertaken in accordance with the specification agreed with the planning authority. That would usually specify the nature of any reporting that is required as part of that.
I was just going to suggest we should just take out the reference to Kent County Council in 5D, because the post-excavation assessment shall include, and then that specifies what's in there, and then if it's got to be approved anyway,
You will know what the Kent County Council's requirements are.
In terms of, yeah, I don't know if there is, because I would rely on the Kent County Council archaeologists to provide this. However, we can ask the question to the ecologist.
I think the suggestion that Mr. Hardy made is probably the most useful, because it doesn't,
If you're not aware of a document, then that's fine.
I'm also happy to remove it.
because it
tells you what's got to go in it.
as it says, you've got A, which is the full document that you're going to receive and approve. And you will determine whether it's in accordance with your requirements and anything that Kent County Council may come up with.
Yeah.
Right. 6. Where it talks about the highway, is that meant to include public footpaths as a highway under the Highways Act? Or is did it relate just to the Old Street? It's the same with bound surface for 5 metres from the edge of the highway.
My understanding that's from the vehicular highway, not.
Old Street. 'Cause if
Yeah.
it's using the access from Old Street,
Yeah.
then it's, that's already surfaced. If it's meant to be Vigo Lane as well, where the tracks,
crossing.
where
It's the
reference-
construction access. There's only one construction access, so it would only be that one point, wouldn't it? from my experience with this condition on other occasions, it's the first 5 metres from the vehicle highway to prevent dirt and debris going out onto the highway.
But I think I would agree with that. But the construction compound is within the main entrance. After that, the panels are taken into the fields by smaller vehicles. They would have to cross Vigo Lane, so there would be a crossing point at that point. So that's where I'd read the highway to be.
Okay.
So that would be this up here.
But also across the middle.
What's that? Oh, over here.
Because the panels are going to be taken over.
In that case, it would probably be better to specify from the edge of the highway and public rights of way, but
You wouldn't. Well, you wouldn't want to hard surface
no.
5 metres either side of the rights of way.
Mm.
They're not hard surface though.
So therefore, I think it would just therefore be the highway is in the access point for vehicles
And Vigo Lane.
Yeah.
in Vigo Lane.
Well, can I leave it with you? You can amend the condition to
Yeah.
actually specify the names of the roads or names of the highway, or you can leave it as it is on the understanding that it's essentially just the highway.
Yeah.
The metalled roads. Yes, bullet point 3 of condition 8. That's the final sentence. If dormouse are confirmed, all mitigation licensing will be approved by Natural England prior to the relevant works being undertaken. Well, that's seeking approval from a third party, which is not normally acceptable within a condition. And in any event, is it
Separate legislation
and
anyway.
is it necessary
Yeah.
because
Yeah.
the appellant would have to have any licenses in relation to protected species in place before works were undertaken?
Yes. So, I mean, that could be changed, couldn't it? A non-licensed method statement for hazel dormouse to include an update not search survey, consequential, and if required, consequential mitigation and licensing. Leave it at that.
Well, I'll leave it with you to
I'd have thought
agree
that's it,
upon
just
that.
remove that.
It's this seeking approval from a
Yes.
third party.
We'll just do that.
And bullet point 5 is the same issue. Approval from Natural England is included within there. I go on to condition, well, we've got the additional condition now, or the updated condition 10, which includes the reference to
Metrics, yeah.
delivering a minimum, at least 175% in hedgerows.
Yep.
Or, no, sorry. Overall biodiversity net gain of 175% and hedgerow units of 250%.
Yeah.
Yep.
So there's a little bit of wriggle room because it was 279 or something like that, but it was just to allow the final details.
And that goes to the point of determining
How
what
much weight you can attach to it.
I might attach to it.
Yeah.
Good 14. radon protection. It wasn't clear why this was necessary, given that
It's not as a housing,
there's
isn't it?
there'll be nobody on the site.
Usually,
The
for the
housing,
build,
yeah,
there
would be.
build up a radon underneath slabs. The only point would be the substation.
It's not as a human. It's a human.
No.
A radon.
We don't normally put them in
No,
there.
no.
So
Is that a housing? Maybe a hangover? Is it from a housing?
Now, to be honest, this condition is a legacy from conditions that were applied by the case officer when it was presented to the committee.
Okay.
I haven't questioned it because I imagine it was a good reason to include it. I haven't looked
No.
back into re-justifying it.
I can't.
I have to say I can't see why it's necessary.
No, it's not habitation, so you wouldn't normally.
My only guess would be because of nearby residential properties, but I'm not an expert in the health impacts of this.
Those normally those would have to have their own, because it's essentially the build-up of radon gas that percolates through the ground and gets trapped in a slab of a
Yeah,
of a dwelling.
it's risk to the development itself. So the reason is to ensure the development does not prevent any adverse risk from radon. My understanding is that that's a risk to that development. It's not risk off site, and actually because there's no human habitation, it's not.
Okay.
It wouldn't do anything
Have you
to the
have you
equipment.
come across that?
I've come across it specified before in a substation,
Right.
and it's
Right.
people get finicky on it. It's a nothing item. It's a layer of visqueen, really.
Right.
If it's the substation, that's the concern. I can see the substation is located well away from any properties.
Yeah.
So I would, if that's the concern, then I would.
Are you happy? I mean,
Yeah,
not bothered.
Having a
there's no
basic
radon risk
conversation.
here,
Right.
I
All right.
think.
Shall I leave it with you to
Yes.
discuss and provide, if necessary, a revised condition or
remove it.
delete the condition entirely?
Mhm.
Once you've taken advice as to the relevance of radon in relation to any particular feature on the site.
And storage would need to be removed from that anyway, wouldn't it, prior to first export of energy?
Yeah.
Yes, 15 refers to electricity storage.
Mhm.
Yeah.
Oh, I haven't spotted it on 14. 16, infiltration. I've written down here, sense. No drainage systems, infiltration of surface water drainage into the ground. That didn't make sense to me.
No, the wording is unusual.
I presume it
Doesn't
should
make
say.
sense.
Well, no, I think it should say, is it no drainage systems providing for infiltration of surface water drainage into the ground are permitted other than with the written consent of the LPA. I think that's.
Yeah, I think that's right. I'd just wondered whether it was covered already by the
Suds.
SUDS condition. Sorry, is it? No, sir, 12.
12.
12, sorry. I scooted straight past it.
I mean, we could change this to infiltration of surface water drainage into the ground is not permitted, other than with the written consent.
Well,
Rather than saying no drainage systems at the start of it.
if you go back to 12, it requires a detailed sustainable surface water drainage system to be submitted and approved. So if infiltration was not something that was acceptable, then and it was proposed, you wouldn't approve it. So
That's true.
is
Just duplicates.
16 necessary?
No. My question would be, is it worth adding that into condition 12 to direct the preparation of that SUD scheme?
SUDS,
Is it
a
meant
SUD
to
scheme is-
address the issue of rainwater running off the panels and into the ground?
Yeah.
Well then, a detailed sustainable surface water drainage scheme under
Does that,
section 12
does
will
it?
cover that particular point.
Hmm. Yeah.
I'm not going to dive into over this. I'm happy to remove it. It would be assessed and it would be worked out through that.
We're certainly happy with 12 because that will, by definition, include, surface water drainage features.
Yeah.
That probably will provide for infiltration. Because that's the point.
Just check it out.
Final point is condition 18. Just as a matter of clarity, in the second sentence, after should the word temporary be inserted? So, because as I understand,
should.
from reading the
Yeah.
documents, there's no lighting at all
No,
No.
except for temporary lighting
correct.
somewhere. So,
Yep.
just to be clear, to make it clear.
Yeah, we're
It's
happy
a
with
very
that.
small point and perhaps very picky, but you know. And finally, you've got the new condition 19.
Yeah. I was just on that one, in terms of emergency lighting, if there was a health and safety, if there was an emergency or an accident or something like that, I suppose that would be temporary. Sometimes you see that you know, you might have just have PIR or something like that, but I don't know whether you think
That security or emergency lighting is usually dealt with differently than temporary lighting because it exists for the duration of the development.
I don't know what your suggestion is in how we deal with the conditions. If you were asking us to finalise this with the council following this discussion, then we can, I suggest, put a different lighting condition in. If in fact you don't want any more discussion, you're going to take it away, then we can sort
No,
out.
no, I want you to
Sort it out, right?
look at the points that have been raised.
Yes.
Yeah.
Agree it amongst yourselves, and then provide the case officer with a final agreed list of.
I'm going to
Yeah.
suggest there's another lighting condition which does the same thing but also takes into account security and health and safety stuff.
Either that or we just put
I would
should
put a-
temporary and or emergency lighting be
There's a
required.
better wording,
Yeah.
I think.
Yeah.
I put a time limit on it
Yeah,
by Friday of this week.
definitely we can do
Yeah.
that.
We can
Probably
probably
can
do
do
it.
it this
We
afternoon.
can do it this
even
afternoon.
Just get,
Yeah.
get it done.
I have no issues with number 19, so unless there's a point that was raised. Now, is there anything in any of the other conditions that I've missed?
The soils, yeah. So it was just the addition of the soil
Yeah.
soil pan that we wanted to see. So we'll make it. I think
Yeah, yeah.
thrash it. There's not
Yeah.
much. There's not much
Yeah,
to do.
no,
but we
that's
can
fine.
do that.
Okay. That's the conditions. Now, just emphasise, particularly for your benefit, sir, that the fact that I've dealt with conditions in detail and made suggestions shouldn't be seen that I've come to any conclusion or would be minded to allow the appeal. Something I have to go through, because once I've finished here, any contact other than supplying the revised list is finished. So I'll go away and think and write and hopefully make sense.
Just so we're good for tomorrow to come.
Sorry?
We're doing the details good for tomorrow for you to come and knock at the door and have a listen.
Yeah.
So I have the address. Did you want to just discuss this now?
Well, shall we finish off completely, and at the end, those who are going to attend the site visit will agree. Well, I've said 10, but we haven't agreed a location to meet, so we'll agree a location. Can you print me off a copy of the plan that was provided showing a potential route, and then so we'll agree where to meet after we've finished all the other business. Mr. Hardy, that comes to you. Do you wish to make any closing remarks?
I don't. I think unless there's anything that you feel I can help you with, I think a combination of the opening submissions, which are reasonably full, and then what we've done in the round table sessions is sufficient.
Okay. Right. Well, in terms of there's only one document that's been submitted, which is the technical note on the footpath widths. That's the only document that will be listed as an inquiry document. I can think. So, unless you have had instructions since this morning
No.
in relation to costs.
Yeah, that's not. We're not making an application for costs.
So, unless there's anything else you wish to raise,
Not from us.
No.
Thank you. Thank you.
the inquiry is closed. So, if those who are going to attend the site visit will get.
Yeah, from our side, so it's going to be Mr. Green who goes tomorrow. Are you going?
I'll leave Lucy to it. I'll sit in the car.
Probably just sit. Mrs. Green.
Mrs. Green.
Right.
Okay, you've drawn the short straw. Hopefully it won't rain.
I think it's going to be nice.
I won't be able to make it tomorrow. I can arrange for a colleague.
We will need someone from the